My lord, I had a small request in item number 6. This is that matter pertaining to recovery of forest royalty from private contractors, my lord. In that matter, your lordship had directed that the learned additional advocate general should address arguments on some aspects of section 15. In fact, he was traveling from Delhi to appear with your lordship. He got delayed, and may I pray that matter be taken up tomorrow if it is not inconvenient, your lordship.
Let's see when the matter reaches.
Very, very, very.
An advocate general not there, can we dispose it of without that?
No,
Because at the end of the day,
my lord.
the fact remains that what is the manner in which you are not in a position to do the needful, then obviously this court will pass the necessary order.
My lord. My lord.
Because you see, I fix it on another day, it becomes very difficult. My
My lord. My lord.
my bench is already filled up
My
with
lord.
all the
No,
meeting
I only
matters.
mentioned it because since your lordship had passed the space, I'll be there, your lordship, when the matter is called. Deeply.
I beg to mention item number 23. If it doesn't reach in the first half, can it be taken up at 2
Huh?
p.m.? If it doesn't reach in the first half, my lord, can it be taken up at 2 p.m., my lord?
23.
My lord.
You want it?
My lord, this matter has been listed on number of occasions, my lord, didn't reach, my lord. Can I pray for taking up at 2 p.m., my lord?
Absolutely no. I already have so many matters today at 2 p.m. You may try your luck in the first half, not in the second half.
My lord, first up, anything.
No, let us see whether it reaches or not. Because you see, this is a 2023 matter. Okay, what is the matter about?
My lord, he has been imposed with punishment, but both the punishment under Rule 7(4), my lord. He has reduced his rank, reduction of rank along with my lord, initial grade pay, my lord, he has been given.
That is consequential.
And my lord, the evidence were not appreciated, the defeat evidence were not appreciated, my lord.
But we'll see when the reach. You are working.
Working, my lord.
See, you will get, if you are allowed your petition is allowed, you'll get back everything.
My lord.
No worry.
Obliged, my lord.
Lordship, in item number 4, I have filed an additional affidavit. I will be permitted to call for that. Lordship.
May it please, your lordship. I beg to mention for listing of an WPC on Monday, lordship, 31st. Lordship, actually, I am led by outstation counsel. He will be in Gauhati during that day. So, if
Mention
lordship
it
allow,
tomorrow.
lordship,
No urgency.
please.
I beg to mention item number 7, my lord. On behalf of Mr. B. Rahman, my lord, he is bedridden with flu, my lord, and he has asked me to request your lordship to adjourn this matter for 2 weeks, my lord. Item 7, my lord.
You've taken the consent of the other side.
Yes, my lord, he has already informed me.
Lordship, we have
Is there
filed
any-
the affidavit, but it
Is
is
there
not on
any interim order?
My lord.
Records reveal that a notice was issued on so and so. However, EPD has not so and so, considering the one Mr. Hayat appearing on behalf of and the matter was terminated. on
7,
order
7.
of the court.
7 to
Okay. Has the AFDC filed the affidavit?
Yes, Lordship, but it is not on record, Lordship.
It is seen that the affidavit has been filed by the AFDC pursuant to the directions passed by this court on 24/7/2026. However, the said affidavit is not on record. The registry shall bring on record the said affidavit. Liberty given to the petitioner to file reply thereagainst. List this matter on 20. How much time?
2 weeks, my lord. 2 weeks.
On 25th of September 2026.
Obliged, Lordship.
Lord, motion matter, my lord, may I pray for listing on 31st of August, my lord?
31st of August. Monday.
Monday.
Mention it tomorrow.
Obliged.
One read petition, my lord, it may be listed for orders, my lord, first week of September. Then, my
Monday,
lord,
tomorrow mention it before the normal board. There's no urgency out there. Legal listing.
my lord, it was last listed on 19/1.
Hardly matters. The fact remains,
Second-
first of all, I am only going to take up a mention for listing a matter is only in respect to bench 5.
My
Now,
lord,
the bench 5 is only when I have to take an urgent matter. So therefore, obviously, it doesn't arise for giving you in the first week of September.
obliged.
Yes, what is this?
My lord, both the petitioners, my lord, has got married and my lord belongs from, my lord, practicing advocate, my lord, both the husband and wife. Now, my lord, the difficulty is that this due to interfaith, my lord. Police, bench 5.
Yes.
Now, my lord, once we are married, my lord, happily residing. Now, my lord, the police, initially from the Lamding police station, my lord, is harassing the petitioners, their family, their, my lord, friends, everybody, my lord.
Why?
Because, my lord, they do not like the, my lord, the, what has happened, my lord, initially there was no objection as regards to the, our, my lord, marriage. My lord, as it is between the interfaith, my lord, that's why maybe this trouble, my lord.
Did. Why are you treating it? They have a marriage certificate. Page 31.
That is their allegation, Lordship, but I do not know. I have to get the instructions.
But, my lord, we have
or it
narrated the
is-
facts in details, my lord.
Whether because of this they were searched for or some for other reason, I do not know, Lordship. I have to get instructions.
Where are you staying?
My lord, at present in under the Rupsi police outpost, my lord, Dhubri.
And they have mentioned 2-3 outposts,
And-
police
and-
stations.
and tell me, where is your permanent residence?
My lord, my lord, I am a permanent resident of Dhubri, my lord, the petitioner number 2, wherein, my lord, the petitioner number 1 is also residing, my lord. My lord, I have given in page 4 this petitioner number 2's address, my lord.
Where did you go out there in Arunachal?
My lord, because, my lord, this special marriage, my lord, in the state of Assam was, my lord, is very difficult, my lord. Perhaps that's why they went there, my lord. My lord, but, my lord, they are happily, there is no any objection. And because, my lord, I have heard, my lord, the case had been registered in the Lamding police station as a case of a kidnapping, my lord. The allegation is that the petitioner number 2 kidnapped the petitioner number 1. And, my lord, that case records, my lord, we have received
In
just,
that case,
my lord.
Lordship, normally what we do, we file a bail application.
It is
In the
where?
bail application, the court directs that whether any case is registered in that particular police station or not. If the case is registered, then case diary comes and Lordship accordingly the bail
Case
is
is
granted. That is
registered,
the
would
normal
it be
procedure.
proper on the part of this court to exercise 226?
No, my lord, we are not on that, my lord, because this case had been registered after filing of this petition, my lord, as we have learned, my lord.
When was it
It was
registered?
registered, my lord, though,
Let us see the allegations in there.
my lord, the complete part of the, my lord, FIR we have not, it is a downloaded copy of the online, my lord. May I read over, my lord, the relevant part, my lord? If my lord allows me, complainants.
Let us not make it public. Let me read it.
Yes, 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 my lord. Yes, Azi. আচ্ছা আচ্ছা No, you can switch off the live streaming. অলপ তেনেকুৱা না সেইটো মই ক'ব নোৱাৰিম কি মেট্ৰিমনিয়েল ইছ্যু হ'লে লাইভ ষ্ট্ৰিমিংটো অফ কৰি দিওঁ you can
Matrimonial issue,
মেট্ৰিমনিয়েল নহয় লাভ এফেয়াৰ মানে sensitive issue হয় ইণ্টাৰফেচটো
Second file. Third file.
তেজপত্ৰ কৰি দিয়ে দেব।
FI was lodged on 17/8/2020.
My lord, but yes,
You
my lord.
filed a repetition on 26/8/2000.
6/8, my lord, but when we searched, my lord, in the police station, we did not get any record from the police, my lord, that whether,
As of
yes,
now,
yes, it is here, my lord. We have to go by the record, my lord.
so I
My-
think better of you approach the bail.
My lord, but my lord, as the police is harassing and interfering with our religion, my lord, marital relationship, my lord, some protections, my lord, that no coercive actions may be taken, my lord.
Isn't that enough for a bail, anticipatory bail?
No,
Not
my
to
lord,
take
we can move, my lord, the anticipatory bail, because, my lord, I, as a petitioner number 1, is now before my lordships, my lord, that I am denying that petitioner number 2 never kidnapped me, my lord. Section 85 has been inserted. So,
But my jurisdiction. is
yes, yes, my
limited.
lord, that I can, Lord, I can appreciate, understand, my lord, but only thing is that, my lord, till date, my lord, the police is now, my lord, and the last night also, my lord, there is a search operation made. Somehow, my lord, we are, because, my lord, this is a very, and the guideline, my lord, which has the Honorable Apex Court has recently issued, my lord, in this type of cases, has also, has a relevance, my lord, and I have find out a very recent judgment, my lord, has been delivered by the Honorable Apex Court, my lord, that how
The
this,
advocate is, yeah,
my lord.
it is practicing in Gauhati.
Yes, yes, my lord, my lord, both are practicing in Amity Court, and the petitioner number 1 is also, my lord, known to everybody, my lord. She comes to court, my lord. My lord.
We do one thing. If it is so, let us, because there is the allegation of kidnapping. But let us have a, what do you call, in-camera proceedings on this, meet the petitioner. The petitioner can, if they are advocates out there, then we pass appropriate orders.
My lord.
They are advocates out there because I
Lordship.
see they are member of your bar association.
My lord. My lord.
Have it in my chamber during the sess and thereupon pass an order.
My lord. My lord.
There's no question of taking any action if they are because
Lordship.
they are obviously they are
Apart from that, they are major also,
because
Lordship.
they are already 31 and 35 years
Well.
old. So there's no sense in respect to this FIR. Whatever FIR is this, we pass an interim order. You get it? Because otherwise, unnecessary. And I know why this has happened, most probably because they got married out there in Arunachal.
And due to interfaith also, my lord.
Lordship.
That is the main reason.
Understood. That is why this is a
Well.
new escape route.
My lord, they were in love relation since JB College, my lord, when they were studying there, my lord. That relation culminates into the marriage, my lord. Both are loyal to each
But
other. my
one
lord.
question duly arises, Mr. Bhuya.
My lord.
The registering authority
Well.
has to register within his jurisdiction.
My lord. My lord.
Just for example, the registration of a death, the registration of
yes,
a
yes.
birth, registration of all marriage
My lord.
has
My
to
lord.
be within the jurisdiction
That is correct, my
where
lord.
the person
My
resides.
lord, I cannot deny that.
You have categorically mentioned the wrong address in the marriage register.
No, that is correct. No, my lord, I have gone through the special marriage act, my lord. If a person reside within the jurisdiction for a 30 days, my lord, then I think, my lord, it can be, my lord. Then, my lord,
Anyways,
Well,
I'll do it.
well.
Recessot দিব lunch hour. Ask both of them to come along with me.
today, my lord. Today, my lord, they may not be available in Guwahati, my lord. So by tomorrow, I can ask them, my lord. So my lord can fix.
That means I'll have it, then the matter, another court.
My lord, can we fixed it as a part heard, my lord, as my lord?
Absolutely no, without even issuance of a notice.
My
how
lord,
can I
my
do?
lord. My lord, I will take a call, my lord. If they can appear in the second half, my lord, I will inform my,
Let me know.
my lord, my lord. Obliged, my lord, deeply obliged.
Mr. Goswami, you are waiting for which item?
One, I think,
Okay. Let us take item one first.
Lordship, in this case, we are going to file affidavit tomorrow, Lordship. Today we'll be receiving, Lordship.
Which one?
Lordship, the item number 1 for response number 3, 4, and 5.
What is the matter about?
That
That
could
cancer,
be of a
young
claim.
boy suffering from cancer, my lord.
Oh, that one.
Yes,
Lordship.
your lordship directed them to file the affidavit. They are filing tomorrow.
Tomorrow, Lordship. Today we'll be receiving, Lordship. If possible, I'll file today itself.
You are filing for the insurance company.
Lord, I am appearing on behalf of IRD. Lord, I had an interaction with them. They would like to file their affidavit within a week.
Okay. File your affidavit. Don't delay it because this is a case
Yes,
where
yes,
I think earlier the matter came up before me. I remanded the matter to the ombudsman and thereupon the
Yes.
petitioner is again here. So it is a question of his treatment. So therefore we require the matter to be done urgently. Okay. Mr.
PP Doctor.
S. Dutta, the learned senior counsel, assisted by so-and-so appearing on behalf of the respondent number.
Respondent number
No,
two.
respondent number 2. And Mr. P.P. Das, the learned counsel appearing on behalf of the respondent number 3, 4, and 5. Submits that within a week's time, the affidavits would be filed. Post list this matter again on 10th of September 2026. The affidavits be filed on or before 7th of September.
Okay.
কোনোবা ICT মানুহ আছে নেকি? Next. লিষ্টখন কেনেকে পাম?
May it please your lordship. In fact, I have completed my arguments in the first round, but they have subsequently developed their case. Basically saying that they have raised several grounds. One is that one particular notice invited 100 candidates for the interview, although we said that every day we'll be taking about 30-40 candidates. So that is one ground they have taken. And also they have said that the decision of the joint committee to have 3 categories of marking for the interview. 10 for the academic part, then 70 for the various qualities of an advocate, and another 20 marks in a third category. They are saying that we have to notify them. that is not notified. Therefore, the whole process is vitiated by non-transparency. These are the two basic major grounds which they have said, and they have relied upon some judgments also. So my first submission will be, and another submission was that a joint committee did not taken into consideration all the board members while taking the decision. So in support of my first submission, whether the selection committee can devise a particular method of assessing the candidates in the viva voce test, and whether it is required under law to notify them. The provision is very clearly stated, and they have taken a support of a decision of Dr. Kusha Kumar Sahu versus State of Orissa, that it has to be notified. I'll come to that judgment. They have quoted that judgment in their affidavit also. If Lordship is pleased to look at Rule 19, Sub-Rule 2, Procedure of Direct Recruitment. Sub-Rule 2 says, evaluation of the candidate with substantial experience for the highly skilled roles like public prosecution would require specialized.
Where do I find it? That is annexure?
Page 139 of the writ petition, Lordship.
Any annexure?
This is a part of the annexure. Just one second.
Annexure number?
Annexure will be Annexure 7. It starts at page 133.
Yes.
The rules called Assam State Prosecution Service Rule 2023, which was subsequently amended, but there is no amendment of Rule 19. Procedure of Direct Recruitment, Rule 19.1, selection of candidates for direct recruitment shall be conducted by selection board to be chaired by a retired judge of High Court and other members as may be notified by the state government from time to time. Then 2, evaluation of the candidates with substantial experience for highly skilled roles like public prosecution would require specialized testing for assessing the requisite qualities, drafting skills, analytical and presentation skills, mental agility and quick drafts of the arguments, and quoting judicial precedents, etc. Accordingly, the selection board may devise appropriate method of proficiency cum skill test by conducting a viva voce test. This is decision of the majority of all the members, including the chairman, shall be the decision of the selection board, and no member of the selection board shall abstain from decision-making meeting of the selection board. A true and faithful record of the proceedings of the selection board, authenticated by the chairman, shall be maintained. And rest are not very relevant. So for our purpose, these provisions are important. So now, under this rule, the selection board is empowered to devise an appropriate method to assess the various qualities which you are looking for in the candidates. But the rule does not lay down that this procedure or the method which they have finalized has to be notified and inform the other parties. That means the candidates. So now what they have exactly done, what they have exactly done, this board, Lordship will kindly come to my first affidavit. So when the board was constituted, Lordship will find that in my first affidavit, which was filed on 5/6/2026, a 4th day of May 2026, 4th May. A running page will be 166. Have Lordship got it? Yes. So this is the first notification to constitute the board in pursuance of Rule 15 of the Assam State Prosecution Service Rule 2023. The governor of Assam is pleased to constitute the selection boards. Lordship will kindly mark these boards with the following composition of selection of candidates to the post of public prosecutor, additional public prosecutor, and assistant public prosecutor. So 3 number of boards were constituted. headed by 3 retired High Court judges, and other members are including a representative from the Advocate General also is there. Then 1 expert from the related field to be nominated by the chairman of the board, 1 member nominated by the learned at AG, then 1 member from the National Law University and Judicial Academy, then Secretary Home and Political Department, as well as Legal Remembrance and Secretary or his nominee. So these are the persons of the board, and roles and responsibilities. Lordship will kindly come to the next page, very clearly written. And this has been supported by the statute, that is the law, rules. Whatever is given there. Selection of candidates for direct recruitment shall be conducted by the selection board to be chaired by a retired High Court, judge of High Court and other members as may be notified by the state government from time to time. Evaluation of the candidate, that is 19.2 is quoted. Roman 3 is also quoting from the rules. Then 4, true and faithful record of the proceedings of the selection board authenticated by the chairman shall be maintained. 5, selection board shall in discharge of their duty be guided by any general or particular directions may be given by the government. After holding the examination, the selection board shall select the candidates in order of merit according to consideration reservation, SC, ST and other categories. So here instead of the examination, it is the vivavocy test. The selection board will finally recommend the names of successful candidates to the appointing authority. On the basis of this notification, the first meeting was held on 13th August 2024. Lordship will find that in Annexure 2, page 168. So here, section 19.2 is very categorically stated, which empowered them to devise an appropriate method of proficiency cum skill test by candidate by doing the vivavocy test. Now, last paragraph, having regard to the aforesaid provisions of 19.2 of the rules of 2023, as well as clause 2 of the notification dated 26/2020, which I have just placed, it has to be understood that the role.
Mr. Advocate General, let us see, I have understood the submission of 73 and 162, what they are making. Now kindly come to the judgment in the case of Dr. Krishna Chandra Sahu.
Yes, last paragraph of that judgment
No,
is important.
paragraph 31. Paragraph 31 gives there are 2 aspects. One is paragraph 31 says that if the rules have stated the power has been given to the selection committee,
Exactly.
they can devise. Now, that is one. Here the rule 19.2 categorically mentions so. Apart from that, this constitution which have been made by 26/2024 can also to be construed as a direction in terms with sections 162. And thereby, at these roles and responsibilities and the evaluation has to be given to be done by the selection board. So therefore, that is taken care of.
That is taken care of. If that is the opinion of the court, I am more than happy.
No,
And
I-
I would like to add one more line.
I only.
I want to add one more line that is very critical. Why this 70, 2010 is required? There are 3 boards. Had there been 1 board, this would not have been required. Whatever one single board have done it, it is common to all candidates. Here's the same number of candidates. There are 3 parts, 7,000, out of which are about 3,000 appear. So 1,000 will appear before board 1, 1,000 will appear before board 2, 1,000 will appear before board 3. So there should be uniformity amongst the 3 boards while giving marks. Therefore, knowledge of those device or that method is not supposed to be known by the other side. It is not for them. This 70, 20, 10, that is for the internal purpose of the 3 boards, so that when they assess the academic qualification, the maximum mark they can give is 10. Suppose one board is following that, another board is that I am for academic qualification, I am giving 50. There will be disharmony. It is not causing any prejudice to the candidates. Their whole case is that 70, 20, 10 formula is not known to them. How they are prejudiced? The same formula is applied uniformly to all candidates. And for the internal marking system, the 3 different boards, they do not sit together. They sit in different dates and different rooms.
You have mentioned it in your reply, this aspect.
No, this is my argument. This is a legal argument. But that is why I said 3 boards. When I said the first annexer, I said Lordship will mark the 3 boards. 3 boards are there. Board 1, board 2, board 3. 3 candidates will appear before 3 different boards. There should be uniformity in giving marks in each category. So this he will not cause prejudice to the candidates, because the candidates who are acquiring the highest academic qualification, they will be assessed at the highest full mark of 10. For the other proficiencies, 70, and mental agility and etc., smartness, all these things, 20. So there will be no discrimination amongst the board in allotting marks or in assessing the candidate. So their whole case is on a very weak footing, that non-disclosure of this 70, 20, 10 method is causing prejudice. And their contention before the court is, after appearing in the interview and after going through the affidavit, they have come to know. Had they knew it earlier, then they would have challenged it to come out of the legal of the various Supreme Court judgments, that once they appear in the interview, once they come out unsuccessful, they cannot challenge it.
Submission is 70, 30, 10.
Yes, 70, 20, 10.
70, 20, 10 have been done only to maintain a uniformity amongst of the assessment made by the 3 boards.
Exactly, Lordship. If I go further of that decision of the board in its first meeting, Lordship will kindly come to page 169 once more, because my whole argument will be based on this.
Yes.
So had there been single board, this mechanism would not have been necessary also. Now coming further, page 169. In the joint meeting, it was unanimously.
See, there is also a contemporaneous challenge to the rule 19.2.
That is before, that will go before division bench.
That's before the division bench. So, irrespective of 19.2 being struck down, if it is struck down also,
Lordship.
then also it is saved by this notification issued on 26/2024.
That will cover 162.
That is when. So, irrespective of 19.2 being struck down,
Lordship.
then also it will cover by 90 this. It is done under 162.
I am on the same page with the Honorable Court on this.
Because this court will, when it writes the judgment, will also think about that irrespective of that also.
But
it is being
otherwise,
taken
Lordship,
care under
there is no anomaly in 19.2.
No, I'm not there. I'm not.
I will
making
argue
this.
that matter also.
No, that is a different thing. Because
Otherwise
you see,
also.
if I am holding it, would be in advance that irrespective of the tomorrow division bench holds it back or whatever may be,
Yes, sir.
would not impact the decision taking into account this is now done under 162.
We have a cushion. We have a cushion to fall back. So may I continue, Lordship? Page 169. In the joint meeting, it is the unanimous decision of all members, including the chairman of the 3 selection boards, that the vivacy would comprise of 100 marks, with 70 for assessing the requisite qualities, drafting skill, analytical presentation skill, mental agility, quick grasp of the arguments and quoting judicial. 20 marks for assessing the requisite qualities of personality, temperament, and 10 marks for the academic, etc. It has been further decided, this is what is important. It has been further decided in order to aid the assessment of drafting skill, analytical presentation skill, mental agility, and quick drafts of the arguments and quoting judicial references, etc. The respective candidates are required to produce before the selection board at least one copy of drafting of any applications, petitions, appeal, etc. done by the candidate himself, which has been filed and registered before a court of law in any criminal proceedings. The candidate shall also be required to produce 6 copies of any judgment order that may have been passed by a court of law in any criminal proceedings in which the candidate himself appeared, conducted, and argued the matter. In respect of the candidates for the post of additional public prosecutor, the number of orders of judgment required would be 4, and for the assistant public prosecutor, it would be 3, meaning that the required number of 6 will be for public prosecutors only. As is the established principle having the approval of the honorable courts, providing that if a selection is held solely on the basis of viva voce test, ideally the test ought to be 6 to 7 minutes. Accordingly, it is also decided that the time to be devoted to a given candidate would be 6 to 7 minutes. None of the candidates, I have gone through the whole petition. None of the candidates has pleaded that they were not given this minimum time, or they were not asked any questions. What was the case in the constable cases and other cases? It is for 15 seconds, 20 seconds, one person goes and comes out of the room. Here, that is not the pleaded case. So whether it is 6 months is sufficient or not sufficient, they cannot challenge because they have not raised any objection before this court also or before the board also. So there is no pleading to this effect. Their only contention regarding the time is that 100 persons were called on in the month of February when the interview process started sometime in August, late in September. After 5 months, I'll come to that justification also. So 6 to 7 minutes they were all getting. In fact, 20 to 25 minutes everybody got. That is why they did not raise any objections regarding the time limit, which is not sufficient for them to place their various qualities. The date and time of the viva voce shall be conducted, shall be decided and informed from time to time. It has been decided in the joint meeting that the viva voce for the post of public prosecutor shall be followed by a viva voce test for additional PP, and thereafter the viva voce test for the post of assistant PP. It is clarified that in the joint meeting that the requirement to bring one copy of drafting and copies of judgment, etc. by the candidates is not to be construed as an eligibility condition, but only to facilitate the evaluation of the candidates. This is also important. It is not an eligibility criteria, but it is for assessing the candidates, these documents which we are requesting them. The follow-up action of the issuing call letters to the respective candidates shall take place and be done as per schedules to be decided by the respective boards. Further, the date, time, and place of the viva voce would be provided in the notification by various departments, how it will be done. Now, let us see the admit card. What is necessary for the candidate to know is that how they should prepare and what will be the area on which they will be assessed. Therefore,
Yes, admit card, which annexure?
in the advertisement also, we have mentioned about the skill level things, and also in the admit card. Lordship will kindly come to page 116, annexure 5, collie.
Yes.
Serial number 5. This is the admit card for the post of additional public prosecutor. Serial number 4. Candidates are instructed to bring the original documents pertaining to educational qualification from HSLC onwards up to graduation and LLB for verification. Every candidate shall be required to produce before the selection board at least one copy of any applications, petitions, appeal drafted by the candidate himself, herself, and filed in the register and registered before a court of law in any criminal proceeding. 6. Every candidate shall be required to produce before the selection board. This is 4 because this is additional public prosecutor. 4 copies of any order judgment passed by a court of law in any criminal proceedings in which the candidate himself, herself appeared, conducted, and argued the matter. So we have notified them what is required. So they know that the questions will be asked from the cases in which I have conducted. Number one, the applications which I have drafted and filed. The judgments, orders, etc., which were given in my case, where I appeared or conducted the case. And everything is within those parameters, within that area, within the campus of his own materials. He was not asked a question from the sky. So he could very well as know that my questions will be asked from this, and there is no deviation. So what was required to be notified is already there in the admit card. 10, 70, 20, that is not notified to them because that is for internal purpose. And they were not prejudiced or adversely affected in not knowing the 10, 20, 70 formula. All the candidates were based and assessed on the same parameters, yardsticks, same levers. So this is notified to them what was required. So in that view of the matter, this argument that they did not know what will be asked, what will be the marking system, etc., in my humble submission, will not be acceptable in any judicial scrutiny. After the three boards conducted the interview, they sat together to collate the marks, and all the members were present. The other day they were saying all members were not present. No, it is not correct. All members were present.
They are saying that this selection which was made in the minutes which is there, which we have enclosed to your affidavit at Annexure 2, this was not signed by all members.
I have the documents.
Page 168. 168.
Perceptive. One 162. 160 to 70. Three persons have passed the order. So I have the documents. If Lordship wants to see, I can place it.
That is already there. My only question they are
So
saying.
there is a annexure of the persons who are present. There are about 20 persons.
To this document.
Yes.
There is Annexure 1.
Yes. Meeting.
Annexure 1 is the document.
I'm just giving Lordship 1 second. Lordship will kindly see this too. At 364, the collation for that part is there. Everybody is present. And so far as this is concerned, out of 20 persons, out of 21 persons, 18 were present. I have the signatures.
Of that Annexure 1.
Yes.
Huh?
Pran Bora is absent. Pran Bora, just learned advocate Pran Bora, senior advocate is present, absent. And majority decision will prevail. Out of 20, there is nothing, no decision as such has to be taken except formulating the method. All district judges were present, all secretaries were present, senior advocates were present.
Now, if we see
And
the constitution,
NLUs, representatives are all present.
The constitution of the year, there has to be the chairman Then the LR.
The LR is present, L or his representative is present,
Alright.
NLU's representative are present, AG's representatives are present. I think Pran Bora was a representative of the,
NLU's
one of the chairman.
representative is number 14, who is present.
yes, Lordship.
Then one of your nomination.
15
has
is
to
also
be there.
present, 15 is NLU, Nihal Chetri, research scholar, NLU JA.
No, no,
16,
this,
Jaiswal is also NLU,
No, 14 is NLU, 14 and 15,
16 also NLU.
and 16 also NLU. Then
Swapna
one
Das
member to be
Datta,
nominated by the learned advocate general, it is there. Additional PP, GP. These are the people, no, you have nominated, Dhanesh Das and all. That's your nominee. One expert will be nominated by the chairman.
yes. These three, 19, 20, 21, they were appointed by the retired judges who were the chairpersons, and they were not part of the constituted body initially.
Okay.
Only 18% are there. If Lordship is pleased to look at the
There are
notification,
18%.
6, all 18 are present.
Therefore, I have looked into this.
Everybody is present.
18 are there.
The chairman wanted some assistants, so assisting counsel. So these 3 persons were assisting the chairman. And if Lordship is pleased to how the, after all the 3 boards done the conduct this interview, that is at page 364, annexure 2. Data signatures, citation. There is no absentee there. And they did not open their seal covers of the interview board marks. Everything was opened when the all 3 boards members along with their members were present. In front of everybody, it was opened.
Yes, last you, what was, who looks in the your judgment book also? Last time you gave me one judgment. What was the name of the judgment? I forgot. Nutan Kumari is there. Yeah, Ramjit Singh, na? That's the case, Ramjit Singh. Where it was challenged at the last moment, they came up with that thing, na?
Yes,
That's Ramjit
That's
Singh.
Para 33 and 38
Para?
to 45.
No.
Para 33, thereafter paragraph 38 to
This one, para 44, 42.
42.
And in these facts, there was one thing, if I could see in the paragraph, on the day on which
Interview was conducted.
where is that paragraph? Where on the day on which the interview was conducted?
Paragraph 30.
Yes. Criteria, 60 marks and 30 marks. So on the day on which the results were published, they have provided the criteria. There are 2.5 of this. Yes, Mr. Advocate General.
So our criteria was already announced in the rules, in the advertisement, everywhere. And fortified by the admit card.
Now, Mr. Advocate General, tell me one thing. If we see the admit card again,
Yes.
lecture 5. Every candidate, number 5, every candidate shall be required to produce before the selection board at least one copy of any application, petition, appeal, etc. drafted by the candidate himself or herself and filed and registered before a court of law in any criminal proceedings.
Yes.
Now, my question is, did you maintain any record? You have admittedly not maintained any records.
They brought it, we are satisfied and they took it back. It is their document.
So the marking must have happened
At the same time.
at the same time.
And because the questions were poured from those materials, those documents, whatever pleadings or whatever materials they brought, the questions were asked from that. And if suppose I do not have any of such materials, that will not be a disqualification. I will still be asked questions.
But one thing, you could very well, as regards judgments, you will be seeing the certified copy or
Yes.
anything authenticated
Yes.
by the court. You can. How do you find out that this is an application filed in a proceedings?
That I think to some level it is trust factor, because when I take this petition, suppose this is the affidavit I drafted and I'll face it before this honorable court. I'll say this is PIL number 14 and this is the affidavit filed by so and my signature
That
will
you have
be-
drafted.
that I have drafted.
So your drafting skills are looked in.
Exactly.
Then
Drafting skills and the reasoning there also. The submissions also in the pleadings.
whatever may be.
Whatever.
So, but how do you know that this is an application drafted by him?
That is why trust factor is also played a maybe role. I cannot straightaway apply, give that answer because Lordship will have to ask this question to former brother and sisters. Not much. I do not have that privy.
No, only question why I'm putting it, because 9.4 says the requirement of maintenance of records. Now, if you have not kept those records, how do you later on, if there's a challenge to that, how do you justify that this was an application?
This is for just for framing the questions, Lordship. Just for framing. I can ask the same kind of questions without looking at those also, materials also. On law points from the statute and from the legal practices. When I ask a particular question from that material, so I can ask about, suppose Article 226. From the petition also I can ask, or the criminal revision petition, 397 earlier, CRPC, or 482 petition. I can ask any number of questions on what grounds a FIR can be quashed or a charge sheet can be quashed. What are the defenses? I can ask questions, but when he brings a particular petition, then I will specifically ask from the factual matrix of that particular case.
So therefore,
There can be general questions, there can be specific questions. So when
therefore,
it is specific, they are more comfortable.
yes, so therefore, your submission is the documents which have been sought for or judgments sought for 5 and 6 is for the purpose of formulation of the questions by
Exactly.
the authority
Exactly.
to
Therefore,
them, and that is therefore not necessary to be made a part of the record.
absolutely correct, because while taking the decision, one liner was there in the last paragraph. If suppose a candidate do not carry these materials, this will not be a disqualification for him. Still, he will be assessed. May I place it once more?
Where?
Yes, it is there.
Just let me know.
Yes.
Documents.
That was the decision document. Place 362, last paragraph. Have Lordship. It is clarified in the joint meeting that requirement to bring one copy of drafting. and-
Advocate General, let me.
Exactly.
So we put it in this manner that the documents which have been sought for at serial number 5 and 6 are for formulations of the questions for assessment of the candidates, thereby aiding the selection process and therefore not required for maintenance of the record.
That is one line. And the next line is that even a person does not bring this also, that will also not be constituted as a disqualification.
Where is that?
Same line. It is clarified in the joint meeting that the requirement to bring one copy of drafting and copies of judgments by the candidate is not to be construed as an eligibility condition, but only to facilitate the evaluation of the candidate. That line is there specifically.
This is can be drawn from that my notes dated 13/8, na?
Yes. So very recent decision, Lordship, in my humble submission.
Okay.
And 19.2 says that we have to look at their drafting skill. Otherwise, what we could have done, suppose he is not bringing a petition or any pleadings, then we will have to ask him, you write a petition, a bail application under 438. Then 1 hour will be required for him to draft a petition in front of the interview board to look into his drafting skill.
Or you may ask on other aspects.
We can ask on other aspects also, but because 19.2 says we have to verify his skill on drafting skill. If he brings it readily with him, then it is saving time and efforts. On the other hand, if he decides not to bring it, then we'll have to request him to ask him to write 1 paragraph or 3 paragraphs
But
or the clause titles.
But that would go against rule 19.2.
No, in front of, just to have their skill. 19.2 is a written test, that is a different thing. Their question answers will be there. This is just to see, like Lordship taking the interview of a stenographer or a typist.
I don't take any.
Whoever.
I'm only in the rule making committee.
Very nice, Lordship. That's why I get sometimes trouble. The legislative department have to step in. I think that is finalized.
That is good, at least something is happening.
Something has settled. So when we take interview of a stenographer or typist, we allow them to type. That is not a written test. So they may be writing, but it is not a part of written test. So this aspect, Lordship, I am done. The other aspect is that why 100 persons on February 19th? Because they are saying that although our standard stand was that we call about 50. When we called 100 on 9th of February's interview, by that time about 6 months interview had taken place. And the authorities came to know that about, if we call 100, about 30 to 40% of them come. So if we call 50, then 20 will come, then the interview board will have to rise before time. Therefore, more were called, but ultimately, whatever was.
There is no allegation by them that they were not granted adequate time.
There is no allegation, no pleadings at all.
No,
I was surprised to
without
find
that
today.
allegation,
Yes,
the question is something like a PIL.
yes, that is one. They are also raising the issue of we are violating the physically disabled persons quota. None of them are into that category. I read every line today. They were raising objection against the physically disabled persons were not accommodated there. This cannot be their case. They cannot hold the brief of a physically challenged person here. So when they say that why we have called 100, out of which 39 appeared from the record.
No, those are things which even I have not thought about it. But they
But
made
I have
submission, but I
addressed-
don't.
I do not know what will
No,
find.
their submissions are on that date. This is to the specific effect. But look here, 73 and 162, and this is being answered by you on the basis of the very judgment they are showing at paragraph 31, which
Yes.
makes it clear. Further to that, it is also mentioned out there that it is your thing comes under 162. So therefore, I put a question to you that even tomorrow 19.2 goes, then also you can fall back upon 162 and that 24/6/2024.
Lordship.
That is one. The second submission is to the effect that this criteria was not announced, so they had no knowledge about this aspect. In fact, these criteria should have been given. In that regard, they have referred to this Ramjit Singh, wherein the facts were a bit different in the sense that initially there was a direction for having a written test as well as another viva voce. Thereupon, on various occasions, it was delayed. At the end, they went for 100% interview. And thereupon, on the date on which the results were issued, they say that we are taking 70% from 60% from here and 30% from there. This is their case. But that has nothing to do out here in respect to the present case because you are assessing on the basis of this. Now, the court out there, if you see at paragraph, kindly come to paragraph 42 of the said judgment in Ramjit Singh.
Paragraph
42.
Further, may I read it, Lord?
Yes.
Further notice dated 11/6/2008 was published fixing 27/2008 for written examination as per criteria.
Come to paragraph 41 onwards. This is
Yes.
how they developed it.
The above proposition has been reiterated in other judgments of this court noted above. In the present case, whether the respondent writ petitioners are stopped from challenging the selection. While noticing the facts of the case, we have noted above that both the appellants and the respondents had submitted applications in pursuance of the advertisement dated 28/7/2006, number 6/2006. In the advertisement, it was provided that the commission may shortlist the candidates for interview by holding a written examination and or on the basis of rational criteria to be adopted by the commission. The commission on 28 December 2006 published the criteria for calling the candidates for interview. Notice dated 28 December 2006 provided that written tests shall be held for the post of PTI on 21/1/2007 on 100 objective type multi-choice questions. Each question carrying 2 marks. The notification also prescribed the minimum qualifying marks 50% for general, SC, ST, EBM, 45 and 25 for assigned to be viva voce. The above criteria was implemented and written examination was conducted on 21/1/2007, which examination was cancelled citing complaints regarding malpractices in the written examination. Further notice dated 11/6/2008 was published fixing 27/7/2008 for written examination as per criteria earlier notified. Before the said examination could take place, by public notice dated 30/6/2008, it was cancelled. Another public notice dated 11/7/2008 was published where the commission decided to shortlist 8 times the candidates on the advertised post with minimum weightage secured in each category. The said shortlisting was also given up by notice dated 31/7/2009 when it was decided to call all eligible candidates for interview. The commission did not publish any criteria or marks on the basis of which interview was to be held. The criteria which was published by the commission on 28/12/2006, 11/6/2008, and 11/7/2008 were given up
step by step and no criteria was published for interview, which was scheduled to take place from 2/9/2008 to 17/10/2008, when the commission had not published any criteria on the basis of which the candidates were going to be subjected for selection process, and the candidates participated in the selection process without knowing the criteria of selection, they cannot be shut out from challenging the process of selection when ultimately they came to know that the commission step by step has diluted the merit in selection. When the candidate is not aware of the criteria of selection under which he was subjected in the process, and the said criteria for the first time published along with the final result dated 10/4/2010, he cannot be stopped from challenging the criteria of selection and the entire process of selection. Further, when the written examination was notified earlier by was scrapped, and every eligible candidate was called for interview, given a go by to a fair and reasonable process for shortlisting the candidates for interview, that too only by the chairman of the commission, whereas decision regarding criteria of selection has to be taken by the commission. The candidates have every right to challenge the entire selection process so conducted. This court in Rajkumar versus Sakti Raj held that when the glaring illegalities have been committed in the procedure to get the candidates for examination, the principle was stopped by conduct or acquiescence has no application. So my submission is that there is a total different factual situation which are different. Our case is that from day one, it will be interview. From day one, the area in which the interview will be conducted were notified either in the rules or in the admit card. And we have not changed the procedure. Whatever was announced in day one, that has been followed till the appointment. So there is no change. Nothing has been changed. Everything was known and everything was notified. Here, the criteria of what is the core issue here, in which area they will be interviewed. Our case is that in which area they will be interviewed, they know it. Everything is known to them. Skill test, agility, grasping capacity, everything. Legal acumen. So everything was known to them.
So you say that in view of Rule 19.2
Lordship.
and the very notification published on 24/6,
Lordship.
this is a public notification.
Lordship. No, that is not public notification.
No, 24/6? Yes, that is a public notification.
Just one second, Lordship.
Annexa 1,
Yes, Lordship, it's
it's a government notification.
it's a government notification, the government, yes, this is,
There's nothing to be hidden out there.
yes.
This is a notification which is issued.
Yes, serial number 8.
Yes. When
Next
it is
page,
a
167,
Uh,
Director Printing and Stationery for publication for notification.
Yes.
So it was
that's what-
notified,
This is a notification.
Lordship.
So this notification provided the manner in which the rules are there, and as well as this notification mentioned, this is to be done.
Lordship.
Now, in this regard, we see the writ petition, which is at again Annexure 5. Serial number 5 is regarding drafting skills.
Lordship. Yes, that is regarding, that is the pleadings they have to place,
And serial
Six
number
is-
6 is for
their performance as a
the
lawyer,
performance as in criminal matters.
Lordship.
So there, here your submission is to the effect that there is the question of changing because in the earlier case, the Ramjit Singh's case is that there was a set of criteria devised at the time when the initial proposal was there. Thereupon, there will be 60 marks, then 30 marks, whatever may be, that was the proposal. Thereupon, there was a written test manipulation, it was scrapped. Second time again, written test, it was supposed, it did not, then it
Scrapped.
happened to be an interview. Interview was held without intimating anybody.
And commission, the head of the commission, he decided, not through the commission, as an individual. That is also there. Here, everything is done by the joint meeting of all the stakeholders. So huge difference, Lordship. We cannot equate. That ratio is not applicable in the present factual situation, which is pending before this honorable court. And so far as the number of interviewees on that day, by that time, I have reply come. Page 480 for a moment, Lordship, maybe please. Put that over today, don't worry. It is for some questions.
A,
480.
which paragraph, means,
Paragraph 6.
no, of which affidavit?
The affidavit, the last affidavit, Lordship, it was on 27/7/2026.
Okay.
আমার এই চার্টখন কিমান এর কৰিলে টোটাল এখন এটা কৰবাত লিখা আছে কোড কৰা আছে না
18/6, no, after that.
This page control দেখি
Internal.
Whose affidavit?
Last.
পল্লৱ জ্যোতি নাথ 27 day of July.
Okay.
Internal piece 9.
এইখিনি আপডেট কৰাই নাই তাত এইখিনি। কোনে 27/7
চাৰ্টখন দিছো প্ৰথমখনতে আছে নেকি মানে এপ্লাই কৰি দিলো আৰু এইটো কেইটা তাৰিখে আৰম্ভ হৈছিল ইণ্টাৰভিউ ফাৰ্ষ্ট ক'ত কমপ্লিট হৈছিল
29 July.
have lots এটা আছে ইণ্টাৰভিউ ডেটটো
29. Yes. Which paragraph?
Lordship, paragraph 6. With regard to the statement made in so and so, the deponent denies that there is inconsistency between the official notice issued for interview on 9/2/2025 and the stand in the rejoinder by the respondent. In this regard, the deponent states that on 9/2/2025, altogether 100 number of candidates were called out, and out of that, the date of viva in respect of one candidate has been rescheduled as per his request. Out of 49 candidates who were called for viva in the morning shift from 10 a.m. onwards, 22 candidates attended the viva voce, and out of 50 candidates who were called for viva in the evening shift from 2 p.m., 18 candidates attended the viva. So on 9/2/2025, altogether 40 candidates appeared in the viva voce before the board number 1, and some of them were given 20 to 25 minutes in the viva voce. So they are contested every day. We are calling 50. Why we have called 100? They have questioned that. If we look, Lordship, is page 352. That is the first affidavit, additional reply, rejoinder affidavit by Pallab Jyoti Nath. In page 352,
Yeah. Which paragraph?
this will be A, subpara A of paragraph 5A. Here in the middle, the viva voce interview, about 5 lines from below. The viva voce interview were held for a period of 77 days from 17/8/2024 to 8/4/2025 at Assam Administrative Staff College, Khanapara. Interview for the post of public prosecutor started on 17/8, continued till 5/9/2024. Interview for additional public prosecutor held from 24/9 to 23/12, 3 months, and post of additional public prosecutor from 27/1 till 8/4. Total 2390 candidates appeared in the viva voce from the 3 categories. Lordship will now see the chart. So for public prosecutor, application received is 753. Number of candidates appeared is 432. Number of candidates absent 229. Additional public prosecutors 1630 were the applicants and 771 were present in the interview. Assistant public prosecutor 2855 were had applied and 1187. So here Lordship will see the percentage of decrease, the decreased percentage. So about 30% came. So therefore, in the month of February, when this category interview was going on, the board decided that we'll call more so that whoever comes can take interview. Although it is for 100, it was well established by that point of time that the number of present or appearing candidate is much less than what is it called for. So this will not vitiate the selection process. And it is neither their pleaded case or anybody's case that we did not get sufficient time. So whether we call 100 or whether we call 50 or 20, it is the domain of the employer. So there is nothing wrong in that, but they are trying to make out a case. So when an attempt is made, a mountain out of a mole, then we have to counter. So in that view of the matter, Lordship, I have completed only the judgments. I'll not place the judgments. I will just refer the judgments. Lordship may take a note of that. In fact, the judgment which they were very forcefully relying, that judgment is in our favor. Tej Prasad Pathak, that case. I'll just give the references, paragraphs. The judgment will help us, our case.
Tej Prakash.
Yes.
Tej Prakash is nothing to do with this case.
One thing is that
because Tej Prakash has different aspects. First is at the time of issuance of the notice, you cannot change the criteria. But once that the criteria is being set out, thereupon the selection body can move into. There's no problem with that, Tej Prakash. They were referring to that paragraph which has, see, if you see.
they were also bringing the ambit of Article 14 there. Violation of Article 14.
Why?
I do not know, Lordship, but there is absolutely no violation of Article 14. Everybody is taken on same level playing field. If anybody is discriminated, they have to count out a specific case. That I did not get this kind of time, or any particular individual pleadings has to be there to make out a case of discrimination. That is not there. Just saying that there is violation of Article 14, there should be two groups. When we say that Article 14 is violated, that means what they are trying to say that I did not know this method of 70-20-10 formula, and therefore I am discriminated. No, everybody was assessed on the same parameters. So Article 14 cannot be invoked in this case, number 2. And number 3, there is no illegality. And another ground they were harping is arbitrariness. Where is the arbitrariness, Lordship, here? These selection boards take any decisions which can be termed as arbitrary. They have to point out. And unless there is any case of specific mala fide, I will place one judgment that Honorable Court in normal situation will not interfere with any selection process. That judgment I will give. Very recent judgment, 2023. 2023 volume 17, Supreme Court cases 147, paragraph 31 to 37. All the previous judgments were analyzed and Paragraph 31,
page?
selection process for public employment, interference by courts.
Page?
It will be page, Lordship, it will be 147.
What is the name of the judgment?
Tasveer Singh Sodhi and another versus State of Jammu and Kashmir. We have extra copy, we can send. But very whole category is there in which situation the court may like to interfere. So all those situations are envisaged and discussed. So unless there is a specific case of mala fide,
Which paragraph you are
paragraph 31 to 36, 37. Various judgments are discussed. Up to 37. So this judgment I am relying
31 to 37.
37. Madan Lal, paragraph 13,
Which one?
14.
31.
And another three paragraph 50, 56 to paragraph 60.
What does it say last, at last? Yeah.
Paragraph
37, huh?
37 is the first category.
Thus, the courts, while exercising the power of judicial review, cannot step into the issues of selection or review.
And paragraph 56 to 60. Then Madan Lal, paragraph 13, 14,
Paragraph 66 to
60.
'56 to 60.
Lordship. They were also raising an objection that no audio video recordings was done of the interview. That is another pleadings. I find very interesting.
You are referring to paragraph 60.
Yes, no. In the that I have completed, Lordship, up to paragraph 60.
Now, in our view, it was with a view to preserve the standard of selection and not motivated by malafidis or
Yes.
higher qualification. In other words, minimum marks awarded for educational qualification was 65 and could increase to year depending on
So there is no case of arbitrariness, Lordship. There is no case of violation of Article 14. No case of discrimination. And as they could not raise anything that there is mala fide, exercise of power, that is not their pleaded case. So in that view of the matter, my humble submission is that there is absolutely no merit in the case of all the writ petitioners. And this is a fit case for dismissal of the writ. Highly obliged for giving me a patient hearing.
Okay, you do one thing, you have given me those judgments.
Yes, doctor.
And Mr. Nath, you have also given me some judgments. Give me a list of what are the judgments, both of you, where you are relying
Paragraph also will.
with paragraph. And as regards you have given me two judgments. You want to add one more? Show me that. Which one? 2020? 2017. 357. Okay, let us look into this judgment.
Another one already I have given, but even in a matter of legal non-running, once you appear, you cannot mind.
Mustaq. I would get Mustaq.
Which paragraph you are referring to?
There are 11, 12, my lord.
The basic issue that was addressed by the division bench was that the appellant having participated in the fresh round of Silla could not have been permitted to essay in the process once they were declared under on this aspect of the in the fresh process of selection. The declaration of
Phase process. Appellants were agreed by the decision to hold a phase process. 11 and 12.
which paragraph?
11 and 12.
12, my lord. The appellants participate in the phase process of selection if the appellant were agreed by the decision of the whole phase, but did not consider their evidence. Instead of they participate in the phase process of selection, it was only often for the answer. It not it only often the answers to the Senate and result in the fiction research clearly not often to the appellant, the principle of estoppel will occur.
But here the court did not decide anything.
My lord,
Where did it decide?
lordship can
Kindly come to paragraph 20.
my lord.
They refer to Raj Kumar. Okay, then see paragraph 21. The court just sidetracked it. This they refer to Raj Kumar. Then you see paragraph 21.
After the participation process, to question the result. Once they will declare the answers in the process, predicted what is the common that six candidate who will ultimately both in the first process, the subsequent selection, one candidate is stated that
Issue relating to fresh selection.
Now, this is an important judgment which may be relevant. 2016 1 SEC 454. Kindly read paragraph 19.
in the present case regarding my are not have to appellant were clearly on notice when the first selection process took place that written examination their 90 mark and the interview and the appellant participate in the selection process. Moreover, two other candidates in the we that the High Court noted that in judgment that the interpretation of Rule 6 was first written as this, never any another body of getting ability to approve adopted by the High Court, there was an amendment of the where the Rule 6 which dealt with the promotion made incorporated in the examination of the Stephen Tusky where the unqualified marks are also incorporated.
This is the most important line, the last line.
However, no this was established to have been caused in the appellant. So if it was earlier it was 85-15, now it is done in 1910.
So therefore, what is to be shown is the prejudice, which the Advocate General has been submitting. So this is the line which says that when you change, even if you change the number of marks or put it 70, 20, 10, there has to be an apparent prejudice shown. And if the prejudice is not shown, the court would not enter. But not the entire part of the judgment. The remaining have no relevance.
But principle laid down that once you appear, without
No, obviously, once you appear, if there is an apparent illegality, then obviously the court can very well look into it, because this court cannot also they say that in view of the judgment passed in that the doctor, some What is that
No,
name?
that's
Manju-
a Dr.
What is that?
Sai.
Nita Sai, Nita Sai,
Different
Nita Sai.
Nita Sai is different putting. That is the interpretation of rule, my lord. Interpretation of, my lord, your lordship can you see
No,
that?
no, 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 not on the interpretation. Says that if you don't participate out there, what illegalities were committed inside the meeting, selection you cannot know. But one has to also understand that you can't keep on these type of, you see,
Yes.
the only ground on which the petitioner is able to sustain the or trying to sustain the question of estoppel is on the ground of criteria.
Correct.
Otherwise, they don't have a case. They have to overcome the criteria business. Once they say that, okay, the criteria was not known and it had become arbitrary, then only the petitioner can go inside the merit. Otherwise, till then,
Otherwise,
it is covered by, there's a cushion in the words of the Advocate General, there's a cushion. So he has to first pierce that seal into this selection first with only by the criteria. But for the purpose of piercing that, he has to show prejudice. This is the only problem with the petitioner's case. He, in order that, therefore, it has been the ardent effort of Mr. K. N. Chaudhary, the learned senior counsel, that he is trying to pierce that veil out there by saying that the criteria was not known for which, but for that he has to show prejudice. Where the petitioner is failing till now.
not shown, my. And in fact, my lord,
Mr. Goelda, you understand, there the problem lies. Your entire, although you have argued this, and in my last 5 years as a judge, I have not heard so much of a matter than this. And therefore I thought,
But this writ petition was structured for rule challenge, lordship. That
Huh?
was, writ petition was structured for rule challenge. That's why some
in
pleadings.
fact, by filing in,
I-
by
yeah.
filing a affidavit.
no,
yes,
but then
yes.
also I allowed you to bring whatever it is necessary. All other things, certain things which you have brought in, you could not have. Where I have, but all along I have allowed you to file your all affidavits. In those affidavits also you have to show, but if you make the submission also, if it is against the law also, there might be a prejudice. You see, our submission was tried to develop that if it is in violation of Article 14, then there is no requirement of a prejudice. Prejudice is not there. If it is a violation of a statute, there is no requirement of a showing of prejudice. But here, in order to pierce the veil, you have to show the prejudice. There the problem lies. Anyways, I'm done with your matters. We'll deliver. What?
I fully agree, because your lordship kindly see by filing affidavit, my lord, they have stated that their argument confined only, their challenge made only to the, my lord, procedure. Only the procedure, your lordship kindly see in their affidavit, they have categorically stated, they confine their argument only, of their challenge made only to the procedure. So only to the procedure, everything has been placed by my learned senior and Mr. Advocate has placed, my lord, I fully adopt it. So regarding that total, I have placed this thing. And also Kumar is-
But I think the most pertinent judgment would be the other one. Huh? Paragraph 19 is the most pertinent thing. Paragraph 19 of this judgment.
that is three judges.
No, all three judges, although
all
there are three judges, but all three judges, the subsequent three judges also makes it very clear
My lord.
that if it is a case where there is an illegality in adopting the procedure, which violates Article 14,
Then you-
the court can very well look into it.
you will total not done. But there is no
So-
other pleading.
But for that, he has to first pierce the veil or say that pierce this thing, that look here, this is my prejudice.
Not done.
Yes. I have not written any judgment on selection. Let me write one. Okay, hearing complete. Judgment reserved. No more.
Deplore.
Your dag is
My lord, new settlement operation I have
old,
given
old.
205, my.
And how much was the land?
4 bigha, my lord.
So dag number 2341. Your dag number is what, Mr. Chaudhary? No, now.
Now, there are three guards. 1657, 1658, 136. These are the.
No, what is his dag now? Hey, like to avoid.
202 old.
What is the new one?
New one, my lord, 2001.
Huh?
2001.
2001. Mr. Talukdar, do you get it? Dag anywhere nearby? No. So from dag number 205, various dags were formed, which means 2350, 238,
Yes.
4546, 2345, 2342, 2856, 2338, 2339, and 2391.
From 202, my lord, 2658 and 2657. From 202
Now 2658,
and 2657. It was from
57.
202.
2657, where is 2657?
2657 is below 265.
Hmm?
Below 265.
2657 is where? 2856. 2657 is not here. E 2002 is up on top. But if 202, Mr. Talukdar, if 202 was a compact plot of land, then it 2348 4-4 will also be a part of it?
Not a part of.
How can it be not a part of it? Because it now, it seems to be a road, I suppose now.
In between.
It seems to be a road by which one can go to 2347. One can go, and I think there is a bifurcation in between.
Yes, it's the government, it shows that the government land, that
Huh?
narrow street is shown as a
No,
government.
it not only narrows, it takes a pattern of a L
Cancel.
L shape.
Yes.
So the entire thing is 2344.
2, 3, 4.
Now, if your land is 23, what is your new dark?
My lord, number is 2658, 2657.
এইখিনি রাখি দিব
Also, I have given the original copy of the map.
Mr. Roy Chaudhary, what is your dark number?
New dark number is 2658 and
2658.
and 2657.
2657.
Dark number 202.
2658. 2658. Five seven and 58 on top. 2657 and 2658.
My lord.
Which has nothing to do with dark number 202.
We have got a settlement from the government on paying premium. We have got a settlement to the government on because the land belongs to Bosishto Devala. Bosishto Devala, Hemdabora was the Raya. Then on 59 Act, it was taken over by the government. And the person who in possession, Hemdabora was given patta. Then thereafter, Hemdabora sold 205 to different pattas of 205. And for us, because we are in possession in 202, so government settles that land on taking premium from us, and we have given all the records.
So you have been given 202.
202.
And 202 has various dark.
Only two ducks.
3 that.
3 ducks.
Huh?
3 ducks.
It's a huge plot of land. No.
202.
202 is a very huge dark. 202 is a very big duck.
Because we have been settled with 4 weeks.
No, it is only you because, but otherwise, Mr. Talukdar, kindly show him the map. You see that 202, kindly come to the two things, page 148.
No.
See 202, how big it is.
Very big.
It's a very big land. Now, if you compare it to page 146, you see anything above that triangular shape is 202.
Because we have been settled with 4 weeks. We have been settled with 4 weeks of land.
Maybe these two, the darks which are above, your boundaries now will be as regards 2658. Your boundaries will be on the south will be.
No.
On the south will be 2657.
Yes, ma'am. 2658, south is 2658.
Will be on the north will be various darks.
Yes, sir.
2326.
Alert.
Some portion of 2330, 2334, and 2333. On the west will be many darks. On the east will be. But your southern boundary will be touching upon the petitioner's land.
But those lands belong to somebody else now, not to petitioner's land.
What?
Those lands belongs to different pattas. Those lands was settled with Hemdabora. and Hemdabora sold it to different partners.
Wow, who is the petitioner?
He is the petitioner who is claiming that demarcation has to be done. He was first a power of attorney holder. Now he says that I got a mutation. On a mutation in 1967, 66, when it was already taken over by government. My lord, this government affidavit says the names of the persons who are in settlement. The government,
Where?
my lord, your lordship will find
On page
What?
102.
102, 101. Government affidavit. 102, my lord. Some Ganeshan, Dauka, Sarod Dauka, all the back number page 102. These persons are these are the persons who are in the partners. Because Hemdabora sold to all these persons.
Wait.
Government affidavit, page 102.
The reason why I thought there is some problem is because of page 43. Page 43, who has enclosed this page 43?
Yes,
You.
yes. This land, my lord,
Please, no, Mr. Borwai. Page 43 is a wrong trace map.
my lord,
See, this 202 has become 291. That is the reason why it has happened. Now you see the original, this one, which is
Madam,
being submitted. It
madam.
is 202.
202.
And therefore the confusion has happened.
my lord.
And this land.
And in between your land, whatever may be, that 205, whoever's land it is, there is now a government land.
Madam, madam.
All not, my lord. Exempted. Our land is exempted, my lord. That is why all are acquired. Somehow our land was, that is why mutation, we have a Chitha copy, our name is there. Now, this question is how our name is deleted, and that reasoning is not there. And the earlier occasion, your lordship has a positive direction that it should be given circle officer to explain how mysteriously his name is deleted. Maybe we are not owner, but my name is deleted 67 to 90. And
Let
my-
us see the order of 1/6/2024 now.
Yes, my lord.
Where is that order?
My lord, page 17 line of our my writ petition, my lord. And circle officer has not touched that aspect of this matter. So
You are, what is your name? Nepal Chandra Dey?
yes, my lord.
Huh?
Nepal Chandra Dey, my lord.
Who are you? Who are you? You are Doyle Chandra Dey.
Doyle Chandra Dey's father, my lord, he died. That is why he substituted.
So-
Doyle
So
substituted.
there is a sale deeds of
Yes,
1966 and 67.
yes, my lord. And then mutation also obtained, my lord. And this exempted from this purview of the land acquisition, my lord, it's note 42, page 42, Assamese note. It's clearly, that is why he's enjoying, the Sita name was there till resettlement. 41, 42, my lord, it is written part ko, part kho. One is acquired, it is exempted. In Nepal Chandra 4 Bikha. At present, my lord, Chitha looks like this. I have filed certified copy page.
Don't. Whatever you have done earlier is already.
Yes, my lord.
You have taken.
1967, they got mutilated, whereas the land have taken over by government in 1966 under that Act of 59. And my lord, this
But whatever may be, you are concerned with your own land.
I am only on 20.
Mr. To see page 84, kindly see page 84 along with the trace map. Today's trace map which you have filed. You see on the north of the respondent's land, it is shown as dark number 2334, 2333, 2327, and 2330. I think there seems to be an incorrect thing. It should be 2326. Isn't it?
Here in the circle officers.
There seems to be a mistake out there.
Happy copy maybe there is.
2326. Then on the south will be 2326, 2346, 2342, 2356, 2356, 55, and 2356. Now, how do you get this 2356 here? This is 2356, okay, 2342, 2356, then 2337 and 2336. 2336, yes. So these are the southern boundary. Eastern boundary is 2341, 23462, 62, and GS Road. Okay, this is the GS Road. West is 2325, 325, 2347, and 2334. So here only apparent mistake is in that page 84 is it should be instead of 2327, it should be 2326. So what is wrong with this order?
My lord,
What is wrong with this order?
my lord, first of all, my lord, this 120, my lord, is old map, my lord. When they have make a, my lord, demarcation, 201, this is a part of road. So they have put their chains from 201. So that is, it comes towards the, my lord, west. That was one mistake, my lord. Finally, see page 148. 201 is a part of GS road, my lord. So it should be from Bahini River, but they have not put their chain from there and little bit forward. That is why.
201 has nothing to do with your land.
No, my lord, 202 after that 205. If they put their chain from Bahini River, maybe my land is covered by 205.
Giving court.
No. Secondly, my lord, kindly say page number 76, my lord.
No more.
There is a direction, my lord.
What you are asking is too far, Mr.
My
Baba.
lord, one thing, my lord.
What you are making that submission is absolutely, this court does not find any good ground.
But
Better off if you want to make this submission, withdraw and file a civil suit. Else, I will hold this order to be correct.
My lord, one thing, my lord, if lordship allow me, 2336, they said that it's not a part of 205. But documents, we have the documents, it shows that it's a part of 205. It is the documents. So if my lord, but there is a BB construction.
I'm not concerned with all these things. 233.
My lord, kindly this 2336.
336.
They kept purview of 205. Then
2336.
is they not say that part?
338, 337.
This is kept purview outside the purview. This is GS Road, near GS Road, my lord. This kept, they said that it is not a part of 205, but here construction is allowed 2336. This is in construction, it is 205. BB construction is made on 205. But they said that it is not a part of 205. So these things I am allowed to place before your lordship. Otherwise, my lord, yeah, last night only I received it, my lord. So today it is difficult for me to reply.
2336 is a different land.
Yes, they said that this is not a 205, but permission says that BB construction is 2336. So that means it is a 205. That paper also says that 205.
No, it is not 205. 2336 is a different land.
That is
It
their
has come up-
projection.
2336 has come up from 202.
That is their projection, but
Not their
permission,
projection. This is
permission.
what can be seen from the trace map.
My lord, this press map, that is why we got it. We have to
You
reply.
got a false, incorrect and a
Incorrect.
fraudulent
2047, my lord, actually.
No, Mr. Counsel, you have placed an incorrect trace map before this court, page 43.
43 years, we certified copy.
That is not, whatever may be.
My lord,
I don't know. Where's the
i-
original?
in-
Where's the original certified copy? Show me.
Yes.
Where is that?
That
Where
I
is
should,
it? You
that I
cannot
should-
do like this because that dog, you are putting it at 291.
Yes,
And because of that, all this problem has arisen.
yes,
Because
that,
they have always been maintaining, saying that it is 202.
no, my lord, time to time, duck numbers are shifted, my lord.
Oh, this is-
2341 now become 2347.
Let me dismiss
Malad-
your.
My lord, if I given one chance, my lord,
No, I am not.
then my lord, another thing, my lord.
And why the other petition is filed?
Other duties, my lord.
First, he filed an application of
Malad,
an
sir.
apprehension that circle officer will not pass on.
My lord, when,
Then he wanted to ex parte order to stop my construction of 202.
my lord,
Then, my lord, the circle officer gave
3090.
order, then he files this application.
My lord, thing is that, my
He
lord,
wanted to ex parte against all the construction company. My lord, this power of attorney game is against the constructions of buildings, my lord, over the land.
my,
Those records are here, my sir. Circle officer has come.
Now, who is constructing this? You are constructing.
Well, not VV construction, I am a green tech man.
Now, who is respond number 7 is you?
My lord,
Ashok Garodia is you.
my lord.
Santosh, Dilip,
My lord, my lord.
and Rohit Prasad Agarwal.
Rohitas now, his son has come, he has expired, I think. One of the father has expired, the son has been implemented now.
So you are there.
my lord, what
4 to
happened?
7.
My lord, may I please-
Or no, enough.
Then, my lord, one order reviewed automatically. Your lordship says that how mysteriously his name is deleted. That thing is not come to logical, and they have not given any findings upon that. So that is my.
No, if your name is, go to the civil court.
I know, but
No,
there is.
you say that you have rights over 205.
Correct.
And make it very clear out here that what has happened from 205, which are the drugs which has happened as per the trace map.
Trace map.
Thereupon, if you want to fight, but they have no business out here against
Correct,
them.
correct. But one thing, my lord.
No more.
My lord,
Heard Mr. M.J. Bolwa.
my lord, one thing, my lord.
No.
That order without reviewed, my lord, then your direction is reviewed. That count on logical and how his name is deleted.
Whose name?
This Doyle, the Nepal Chandra, the original owner.
I'm not concerned with that.
But there is
You
that-
are challenging the order dated 1/6/2024.
Yes,
it is
that was-
perfectly okay.
My lord, my humble submission, it should be reflected one line that yes, your name is deleted so and so, but that should be findings. Why they are shy away to give the findings of that?
Now, they have categorically mentioned as regard dark number 205, what are the darks? They mentioned it.
They mentioned
So
it.
they have nothing as regards the demarcation between you and him. There is nothing.
My lord, there is a judicial direction, my lord, and there should be only mention about that, my lord. And whole crux is they are 4 bigha, 3 kota, 12 plus owner. How can they mutation in 4 bigha? That means, and my lord, in RTI reply says, this is says that we don't know whether in 205 or 202 they have taken the settlement. And settlement, my lord, government land, 4 bigha, 3 kota, 12 plus, my lord, that is another aspect. I am not entering into it. I only says that they are coming 95 or 2009. We came 67. Our name is deleted, mystery or whatever may be. So there should be an explanation from circle officers that this reason your name is deleted. And there is a judicial order, your lordship's order. It is reviewed now automatically, my lord. At least they should mention one line, my lord. These are the demarcation we found. They are very much safe in 202, not 205. Fine. And their name in 205 is not now available because this is reason. My lord, we are helpless then, my lord. This is a judicial order. This is reviewed automatically, I think. Your lordship's order. And in their affidavit also they mention that 2 direction is given by the Honorable High Court. One is demarcation, another is how their name is deleted. It should be a common logical conclusion. In a circle officer order, no whisper about that.
Now, heard Mr. M.J. Bolwa, the learned counsel, appearing on behalf of the petitioner. Put the writ petitions. Mr. B.J. Talukdar, the learned senior advocate, assisted by Mr. P.K. Medhi, appears on behalf of the state respondents. The learned senior counsel, assisted by so-and-so, appears on behalf of the private respondents. You are there? Ms. So-and-so appears for the revenue department. Both the writ petitions are interconnected, and accordingly, they are taken up for disposal by this common order. The case of the petitioner herein is that by the deed bearing serial number 4941 dated 16/3/1966 between Bokhisto Dewaloy, represented by Honaton Sharma Doloi, and the father of the petitioner, land at measuring 4 bighas covered by old dag number 205 was leased out for a period of 99 years. Subsequent thereto, in a mutation order reflected in the Sodor Jamabandi of Nisifi Kiraz Patra number 1, the said 4 bighas of land contained in dag number 205 was mutated on the basis of purchase in the name of the father of the petitioner. It is also a matter of record that by the deed bearing serial number 4597 dated 6/7/1962 between Bokhisto Dewaloy, represented by Honaton Sharma Doloi, and Rohitash Agarwala and Shyam Sundar Garodia, a plot of land at measuring 4 bigha 3 kotha 12 lechas covered by dag number 202 old was leased out with a condition was leased out for a period of 99 years. Subsequently thereto, the land in question was acquisitioned under the Assam, what is that, charitable institution?
Assam Religious and Charitable Institution of Public Nature Act 1959.
1959. By the government of Assam. And 4 bighas 3 kotha 12 lechas covered by dag number 202 which was obtained by Rohitas Agarwala and Shyam Sundar Garodia for a period of 99 years, who have obtained a lease for a period of 99 years by Rohitas Agarwala and Shyam Sundar Garodia from Bokhisto Devaloy was settled with Sri Shyam Sundar Garodia and Sri Rohitas Agarwala on realization of premium, and accordingly the settlement officer was directed to correct the records by an communication dated 21/11/1995. It is very relevant to take note of that the petitioner's claim is qua dag number 205, and the claim of the respondent's private respondent is specifically in respect to dag number 202. Prior to the present batch of present petitions filed, the legal representatives of Shyam Sundar Garodia and Rohitas, along with Rohitas Prasad Agarwala, filed a writ petition being WPC number 5449/2019. And the writ petitioner in the present two writ petitions filed a writ petition being WPC number 7184/2021. It was the case of the petitioners in WPC number 7184/2021 that the father's name of the petitioner was mysteriously removed from the record of rights, for which an application was filed before the respondent authorities. On the other hand, it was the case of the private respondents in the present batch of writ petition in WPC number 5449/2019. That a notice was issued by the circle officer dated 13/7/2018 making an inquiry into the lands of the petitioner, of the private respondents. This court disposed of the said both the petition by a common order dated 17/2/2024. Paragraph number 8, 9, 10, and 12 of the said order being relevant are reproduced hereunder. From a perusal of the above quoted of the directions so passed by this court in the order dated so and so, above quoted directions passed by this court, it is clear that this court did not interfere with the notice dated 13/7/2018, which was issued to the private respondents, and rather gave liberty to the the petitioners in WPC number 5449/2019 to approach the circle officer dispute review circle by placing the necessary documents as sought for. Insofar as the reliefs which were sought for by the petitioner in WPC number 7184/2021, this court categorically held that under Article 2 to 6 of the Constitution, the question of granting any declaration to the petitioner in respect to the petitioner's rights over Dag number 205 cannot be granted, and the petitioner was granted the liberty to approach the civil court seeking appropriate declarations. However, insofar as the relief sought for demarcation as well as correction of the records, this court directed the circle officer dispute review circle to bring the said proceedings to a logical conclusion in accordance with law within a period of 6 months from the date of the said order. Pursuant thereto, the order dated 1/6/2024 was passed by the Circle Officer Dispute Revenue Circle, which is assailed in WPC number 5164/2024. The second writ petition, it is also relevant to take note of that on account of not passing the order by the circle officer as per the directions, another writ petition was filed prior to the filing of the Why did you file 3090?
Because NOC was given, my lord, without demarcation. That is why they started construction. We said that.
So
then
this writ petition was the
yes, 3090.
Direction was delivered within 6 months.
My lord, page 23 is the prayer, man. Restricting private.
In the meantime, pursuant thereto, it is noticed that that on account of construction being carried out by the respondents, private respondents, and as the demarcation proceedings was not complete, the petitioner filed a writ petition before this court seeking various directions, which was registered and numbered as WPC number 3090/2024. The learned coordinate bench of this court, while issued notice by an order dated 19/6/2024, while the said petition was pending, the order dated 1/6/2024 was passed by the Circle Officer, Dispur Revenue Circle.
Prior to that, prior to filing of 3090, order was passed.
3090 was
They knew it
The
was.
order dated 1/6/2024 passed by the Circle Officer was placed before this court. During the pendency of the writ petition being WPC number 3090/2024, the order of the Circle Officer dated 1/6/2024 was brought to the notice of this court. On 21/8/2024, and resultantly, the petitioner filed the second writ petition being WPC number 5164/2024, challenging the order dated 1/6/2024. Okay, come back. Challenging the order dated 1/6. This court had perused the order dated 1/6/2024, which is impugned in WPC number 5164/2024. Further to that, pursuant to the order passed by this court on 21/4/2026 and 3/8/2026, an affidavit has been filed by the Circle Officer, Dispur Revenue Circle, which is also duly perused. Upon reading the impugned order dated 1/6/2024 conjointly with the affidavit filed by the respondent number 3 by the Circle Officer, it transpires therefrom that against dark number, from dark number 205 old, various darks were created during the recent settlement operation. They were dark number 2350, 2346, 2345, 2342, 2856, 2338, 2337, and 2391. It is also relevant to mention that 2356 was at a later stage. Partition from was renumbered from DAG number 23, what is that? 40, na? From DAG number 2341. The trace map have been enclosed as Annexure A. The trace map pursuant to the settlement operation has been enclosed as Annexure A. This court have also taken note of that DAG number 202 is completely distinct from DAG number 205. Though the southern boundary of DAG number 202 is DAG number 205. The land of the private respondents, which was initially settled as DAG number 202, subsequently have been renumbered pursuant to the settlement operation as DAG number 2657 and 2658. In the backdrop of the above, if this court now takes note of Annexure B to the said affidavit filed by the circle officer, the record of rights, that is the Jamabandi, have been enclosed in respect to DAG number 202 as well as the corresponding DAGs pursuant to the settlement operation, and DAG number 205 along with the corresponding new DAGs so created pursuant to the settlement operation. It is also relevant to take note of that from Annexure B, In respect to the various dargs which were formed, neither the petitioner nor the petitioner's predecessor's name appear in the record of rights. Your name is not there.
There. And this is all 205. 202, I don't think here this annex. 205, no. name is.
Kindly see Annexure B, page 149, that is 202.
149. 203. Yes, ma'am. It's 204.
Just in the backdrop of the above, if this court now takes note of the affidavit, the impugned order dated 1/4/2024, 1/6/2024, it is seen that the learned the circle officer, dispute revenue circle, duly provides the details as could be seen from the trace map. And the land of the private respondents is clearly identifiable. By the boundaries mentioned in the impugned order, except on the north, instead of dark number 2327, it should have been dark number 2326. Taking into account the above, this court is of the opinion that the order passed by this court the common order passed by this court in WPC number the common order passed by this court dated 17/2/2024 in WPC number 5449/2019 and WPC number 7184/2021. Have been duly complied with in as much as the list between the dispute as regards identification of the land who the private respondents have been identified, have been as much as the private respondents' land have been clearly identified. The trace map further, the trace map encloses an HA to the affidavit filed by the circle officer also makes it clear which are the darks which were created from the original dark number 205 and a copy of the Jamabandis enclosed also shows the names of the persons who have been which have been mutated, the names of the persons who have been mutated against the DAGs in question. DAGs so created from DAG number 205 in question. In view of the above observations, this court disposes of both the writ petition with the following. In view of the above, this court disposes of both the writ petitions with the following observations and directions. The impugned order dated 1/6/2024 do not call for any interference. Number two, the materials on record clearly show that the land of the private respondents is distinct and identifiable in the revenue records. Number three, the various DAGs which have been created from DAG number 205 have been mutated in the names of other persons other than the private respondents. Number four, the question of passing any writ, direction, and order in the present proceedings as sought for by the petitioner the relief sought for by the petitioner in both the writ petition stands rejected. Number five, the rejection of the reliefs in the present petition shall not preclude or prejudice the petitioner to approach the competent court of civil jurisdiction, seeking declarations as well as seeking appropriate declarations and consequential reliefs who are those persons whose names have been inserted in the record of rights. Names have been inserted in the various DAGs which have been formed pursuant to the settlement operation from DAG number 205.
One thing I take indulgence, my lord. Page 115 vernacular, my lord. That is 202 is not written in type copy 202. That, my lord, your lordship has mentioned that 202, my lord. That
Okay,
things, my lord,
202
I want to. In vernacular copy, it is 205, my lord. 202 is in written.
205 we'll put it all 205. The record of rights of all 205 mentioned.
And my lord, regarding that RTI, my lord, I just that says that we have filed RTI. They said that we have no documents.
Mr.
How it
Burua,
makes.
Mr. Burua, you see what you
that
need
is-
to do, there are two things. If you want this portal, therefore I have mentioned it very carefully.
Yes, my lord. I'm sorry.
As in the record of rights, there is nothing. But physically, there might be. You have to understand that. There's a difference between that.
My lord.
So if any possession, you have to, you see, in a very recent judgment delivered yesterday or day before yesterday by Justice Masi, Supreme Court, they've dealt with mutation does not confer any right or extinguishes.
Yes.
Even a rejection of a mutation application also would not confer a title upon anybody, nor extinguish your title if you have it.
If contrary is proof.
So therefore, you need to, a judgment to, judgment is give it to him. You read that, then file a suit. I can't give you any that. And don't bring Mr. S. Bora anywhere near this.
My lord, my death prayer, my lord, your lordship may one line, my lord, there regarding the mysterious deletions that your lordship that
What?
mysteriously deleted my name, my lord. That is in MP
So
not.
therefore, I have granted you the liberty for filing a suit against those persons whose names have been given.
They are,
How can I allow that? Those people are not made the party in this proceedings.
my lord, DC has said that we have
Okay.
no documents. How
Taking
your
into
name-
account that the counsel appearing on behalf of the petitioner has unnecessarily argued after the passing of the
Yes,
order.
no, my lord, just I
This
have
court imposes a cost of 25,000 upon the counsel of the petitioner, which shall be deposited by the learned counsel before the registry of this court within how much? 15 days?
no, my lord, just
Within
after
within 15
I-
days.
my lord, just
Within
after
15 days.
lordship's order, my
Failing
lord,
which-
I said, my
failing-
lord, this, I'm sorry, my lord, I cannot control, but my lord, that should be.
Go, no more.
My lord,
ইন্টারিম অর্ডার দিল
Yes, what is your case?
2026,
Hmm.
your lordship has modified the interim order
Hmm.
that they will that no recovery, my lord, till the matter has not been decided by this court. My whole case is 67. They have every right for search and seizure under 67. There is no doubt about it. My whole case is that demand and recovery can be made by them only after issuing of a notice. Here is a case where search and seizure, after search and seizure, my lord, recovery was made by them, an amount 6.5 crores, 6.5 crores on coercion. And in on protest, we have to give it to them. That's our case. They could not. And plus, professional tax, whether they can levy a professional tax to us or not under GST. And the second point is demand and recovery without giving a notice. That's our case. So cause reply, I participated. Now it is going on, my lord. There is absolutely no issue in respect of someone under 70. I participated, cooperated, some 14,000, that proceeding is going on. My whole case is about the recovery. 6.5 crores they have recovered. That's my only case, my lord.
How they have recovered?
They have recovered. Search and seizure they have recovered, my lord. JLC 3, my lord, please look into it. Under protest at page 76, my lord. At page 76.
So you have paid it, you will get the benefit. What is that?
Under protest, my lord. This is under protest I have paid.
No, they have given you the DRC 3.
Yes, DRC.
And
DRC.
this amount is how much?
6.5 crores, my lord.
Huh?
See, it will be a bit more, you know, Manohar.
How much is the DRC 3?
Yes. At page 76.
6.89 crores.
Huh?
6.89 crores.
This is under protest, my lord, at page 76.
No, it's okay. DRC filed under protest in so and so.
Yes.
So this payment you have made,
I made.
Then
On
what happened?
protest, I made, my lord.
you'll get a refund.
No, that's, if they refund it, that's our prayer, my lord.
Yeah.
That's our prayer only. That's our prayer for refund.
But how can we decide now? When the proceedings under 70, what has happened? You have dropped the 73 proceedings. Use your mic.
Lordship, that information I do not have.
No, Mr. Chaudhary, this has come up for final disposal. And absolutely, this thing, I don't expect that I have no instructions.
Lordship, may allow me.
We are concerned about the matter out there. Call your officer. We'll have the officer. Have the officer ask him to be there in the video conferencing. We are not getting the help from the finance department. No, you no good.
May allow me few minutes, Lordship.
Ask him to be present in the video conference. I think he's a better lawyer he would be. This is not how you practice a taxation matter. You have to be up. First of all, what is the allegation? There was a search and seizure carried out under section 67. After that, what has been done? You said to him, most probably under section 73 or 74, you are not aware. The moment it is a case of the search and seizure, it will be a case under what? 74. Because it is a case of suppression. Now, if it is a case of suppression of here, have you issued the notice?
No.
Then when there is no proceedings out there, what is this? Section 70 notice is just for the purpose of giving him information, asking him to come over and kindly give your statement, whatever it is. That is for the purpose of procuring evidence, section 70. We are concerned with section 73, or is it a case under section 74? And if you have not issued a notice till now, then on what basis did you ask for that? And for that, you need to issue a notice initially. Where is your notice under section 73(4)? Huh? Without notice, how can you pay the money under section DRC 3?
He has made the payment under rule 142 sub rule 2.
Let us read 142(2). But before that, read 142(1).
Yes.
And more particularly, 1B. Read it loud.
Lordship, the proper officer shall serve along with the notice issued under section 52 or section 73 or section 74 or section 76 or section 122 or section 123 or section 124 or section 125 or section 127 or section 129 or section 130, a summary thereof electronically inform GST DRC 01. B. Statement under subsection 3 of section 73 or subsection 3 of section 74, a summary thereof electronically inform GST DRC 02.
So this is DRC 02 is to be given there, along with a DRC 01 will be the notice. Now kindly come 142 1A,
Yes, ma'am.
capital A.
The proper officer may, before service of notice to the person chargeable with tax, interest and penalty under subsection 1 of section 73 or subsection 1 of section 74, as the case may be, communicate the details of any tax, interest and penalty as ascertained by the said officer in part A of form GST DRC 01A.
So therefore, did you issue this notice? That's his case.
Yes, my case is that.
Because this is required in terms which, if you see section 74, 73. (73), the service of such statement shall be, kindly see. 5, the person chargeable, 73, with tax made before the service of notice under subsection 1 or as the case may be, statement under subsection 3, pay the amount of tax along with interest payable thereon under section 50 on the basis of his own ascertainment of tax or tax as ascertained by the proper officer and inform the proper officer in writing of such payment. This is a notice under 73(3). He pays under DRC 3, where before the service of notice, the person he has so and so, so and so, so and so, as the case may be, imposed in accordance with 74(5) of so and so DRC 3. And an acknowledgement under alia shall be made available to the alia through the common electronic portal. Where is it?
381 of their affidavit, my lord.
Page
381 of their affidavit, kindly see the instruction.
81.
381 of their affidavit filed by the
381. I don't
380
have so much of pages.
no opposition, affidavit in opposition.
I have only till page 131. Any affidavit?
Affidavit
that's in
filed, yes, they have filed an affidavit. Please see my lord 381.
Three 381 is what?
The instruction, my lord.
No.
Deposit of tax during the course of search inspection. Whether it is permissible or not, my lord. Kindly see 381. And if you see
My question is, have they issued a notice under 1A, DRC 1A?
they have not issued any notice to us, my lord. That's our case.
DRC 03 has been.
03, he does.
Yes, I paid.
He does under 142(2). I'm not on that, but when did he do? It has to be first done under 73(3) or 74(3). Where is that notice? Then how can there be a payment? So the payment
That's our
return
case. That's our case, man.
Now thereupon, once he has paid that amount, once he has paid that entire amount, then what happens? You cannot proceed. The moment you are satisfied with a DRC 3, you cannot proceed. Then where is the question of section 70 comes, or 73 comes, 74 comes? And what has he paid? Let us read what person has. As of now, have you issued a 74 notice? Are you not aware the matter was to be taken up at 2? Because what has happened is out here as it appears. You try to say, although it is the requirement, this amendment was brought in later on. Now, by this amendment, what has happened that you directly don't issue a 74-1 or a 73-1 notice. Instead of doing that, you intimate him that, look here, this is the amount which we find it that you are payable. Then he may pay the entire amount in DRC 03 in terms with 74.5 or 73.5, he makes the payment or makes an assessment of that and makes the payment. Once that payment is made, you cannot initiate a proceedings under 73 or 74. Now, if he does it on his own assessment, then you may do so for that period. But you have to understand that what is the amount, if we see the affidavit out here, are you saying that the amount of 6 crores is enough? Because the penalty will be 100%. Then there will be interest. So therefore, are you saying that this is the total amount? Because you see, Mr. Gogoi, another aspect is, he has done his assessment. He has submitted his self-assessment. Now that self-assessment has been accepted or not, that is another thing. Here must have, this is for 2020, which period?
This is 24-25. 24-25.
24-25 will be, he must have filed his return in GST at 3B on or before 31st of December 2025. Once he has filed, it is a self-assessment. So the moment, if you are not taking any action and you say that this amount is okay, then you cannot. What do you say?
Voluntarily on the basis of certain made payments against two specific discrepancies out of various discrepancies presented by them to them by the DST official, that is prevalent input tax credit availed from paid.
And this payment was made when?
5th of August
2000?
2025.
5th of August 2025.
Hmm.
And this is for which period?
This is for the period.
No, I don't think this is, when it is a case of input tax credit, input tax, then it will be for earlier periods. One?
154, the last part, indicating availing of ITC without actual receipt of goods. He has paid it, man. Doesn't mean that, my lord, his liability goes.
Mr. Gogoi, you are not understanding me. There are two things. If you are saying that he on his own paid it, now this is not for 2020, when it is a case of ITC credit, then it cannot be on the basis of 2024-25 because he has not filed his returns. You will be analyzing his GSTR 1 and GSTR 3B. And then only you will come to aware that yes, there is something wrong. But for that, as on the date of which it is not the 2024-25. Now, this assessment which has been made, or this search which has been made, of finding that he has claimed certain input tax credit, input tax, without actually selling or doing anything to that effect. That has to be prior there, because input tax credit means it had been refunded. And when will the refund happen? Refund will happen only at the time when the payment has been already, the GSTR has been filed. Meaning thereby, it has to be for the period for 2023, at best 2023-24, where he must have filed his return by 31st of December 2024. So 24, there he must have claimed this input tax credit. So now in that he has made the assessment. Once that assessment has been made, a self-assessment is being made. Now, if you don't issue a notice, and the moment is you are accepting this amount, are you not therefore saying that you cannot take 74 action? How? How can you take a 74 action or a 73 action? Because it is a case, it is not a case as per the allegations in your affidavit, it won't be a case under 73. It is a case under 74. So if it is a case under 74, Then once he makes the assessment and then what do you do?
My
Kindly
lord,
see.
I got instruction, input credit is 23-24, your lordship is right.
Obviously. because
And
you
the
have to
assessment
file
is
your assessment.
24-25.
Yes. Kindly see. You see, kindly see this. 74.5. The person first 74.3. When a notice has been issued for any period under subsection 1, we are not concerned. The service of statement under subsection 3 shall be deemed. Now here you don't have a parameteria provision like 73.3. 73.3 says where a notice has been issued for any period under subsection 1, the proper officer shall serve a statement to that effect. The service of the statement is so and so. Now here you see the service of the statement under subsection 3, under section 74.3, where kindly see before that, the proper 74.2, the proper officer shall issue the notice under subsection 1 at least 6 months prior to the time limit specified under 10. Where a notice has been issued for any period under subsection 1, the proper officer shall serve a statement containing the details of tax not paid, short paid, or erroneously refunded, or input tax credit wrongly availed or utilized for any such period other than those covered under subsection 1 on the person taxable with tax. The service of statement under subsection 3 shall be deemed to be a service under 73.1, subject to the condition that the grounds relied upon are not fraud. The person chargeable with tax may, before service of notice under subsection 1. Now, how does he know about this thing? This is very relevant. Pay the amount of tax along with interest under section 50 and a penalty equivalent to 15% of such tax on the basis of his own ascertainment of such tax or the tax as ascertained by the proper officer, and inform the proper officer in writing of said. Now here at this stage, let us come to 142. 142 1A. This was inserted in 2019. The proper officer may, before service of notice to the person chargeable under tax, interest, or penalty under subsection 1 of section 73, or subsection 1 of section 74, or subsection 1 of section 74A, as the case may be, communicate the details of any tax, interest, and penalty as ascertained by the said officer in Part A of Form GST DRC 01. So, before issuing, it is the duty for you to inform him. Then comes it where before the issuance of notice, service of notice, the person liable with tax may payment of the iman as so and so under 5, or clause 1 of subsection 8A of section iman as the case may be, interest and along in accordance with the provision, or subsection 5 of so and so or iman, or where a person makes payment of alia, whether by on his own ascertainment or iman, he shall inform to the proper officer of such payment. Now he has made the payment under DRC 3, and an acknowledgement in form GST DRC 4, which you have given, shall be made available there through the common portal electronically. Where the person in so and so has made the partial payment of the amount communicated or desires to file submission against the proposed liability, he may make a submission on so and so, that the proper officer may issue under so and so, accepting the payment or the submission of both as the case may. Where so and so is payable under iman, instead of crediting the amount in the electronic liability so and so against debit so and so iman. Now here again we come. Kindly come to 74.7. 6 is information that DRC 3 is filed. Where the proper officer is of the opinion that the amount paid under subsection 5 falls short of the amount actually payable, he shall proceed to issue the notice as provided for in subsection 1 in respect of such amount which falls short of the amount actually payable. Where any such person chargeable with tax under so and so iman with interest under iman equivalent to 25% of such tax within 30 days of the issuance of notice, all proceedings in the sale shall be deemed to have been concluded. So therefore, these are various opportunities. First, you inform him that look, this has happened. He may make his own assessment or pay or whatever it may be. The second comes at the stage that when he makes the payment. Once he makes the payment, you may say, okay, as per me, it is okay, because he has already filed his GSTR. It is okay. Because it is required to be said, okay, because of the fact that all are matters of record. His assessment is already electronically filed under GSTR 3B. So in the 3B, he has claimed this input tax credit and he has got the refund or used it electronically. So this needs to be brought on record electronically, by which the proper officer has to inform him that look here, this is the amount we are satisfied, matter over. But if you are not satisfied, you have to issue a notice. Then he has to pay. Then once he pays the notice, then he pays 25% of the penalty. Because initially it is 15, then 25. Now, when it is an order passed under 7310, 7410, it is 100% penalty. Kindly see, because here not only that, it will also result in a case penalty under initiating proceedings under 132.
It will come back. 74.
Under protest, put voluntary dismissal. Under put voluntary dismissal. Is under protest.
This will be till financial year 73-74. What is 74A?
74.8.
Because this 74A would not come here.
Yes.
Because here 74A, the search was made on 5/8.
Yeah.
So there could not have been a return filed. So therefore 74A would not come. It will come
Search
prior
was made
to
on
not only
31
2023, it may be 4-5 years before also. Now what is the relief sought for?
Well, it is not voluntarily, as my learned friend has pointed out. It is under protest at page 76, my lord. Not voluntary, as my learned friend has said, it was voluntary, we paid the amount. If you see at page 76, under protest. Relief, my lord. Page 28 is a prayer.
No. So therefore, if it is made under protest, I can't direct them refund. But the fact that once this is filed, it is your duty to take up. You cannot sleep. You have to conform to 74(6).
So far as this particular para 25 is concerned. Further, 1.5. 155 over 154 of previous thing. Then what subsequent event has been mentioned. It is evident that the amount paid by the petitioner is to specific not matching the tax amount involved as per
Page paragraph
155 is a continuation of para 25. Page
Yeah.
1. It is evident that the amount paid by the petitioner against the two specific discrepancies do not match with the tax amount involved as per the GST official, which indicates the self-ascertained and voluntary nature of the payments made after the petitioner becoming aware of the decreased penalty liability as as provision in Assam GST Act, therefore the allegation of the petitioner of use of coercive into payment of tax is unjust. Then also we see accordingly all voluntary payments in the next payment. All voluntary payments made by the petitioner were duly acknowledged in DRC 04, which is an acknowledgement of payment made voluntarily. Those GST and portal by the GST officials in order to ensure proper adherence to the procedures established by the statutes and the rules made thereon. And moreover, it may also be noted that the petitioner himself submitted a statement that Kaluwala Construction Private Limited was unable to submit the necessary documents related to certain discrepancies and transactions as required by tax official by so on and committed to submitting all required documents and explanations related to this within 30 days from the date of public statement. That is by
No, all are understood, Mr. Counsel, but my question is, if you mention in your affidavit, that is not sufficient. What you need to, you have to take action under 74(7). Because what he has paid out here, tax amount involved as per the GST official is 39 lakhs. Tax amount paid in DRC is 23 lakhs. Tax amount involved is 6 crores. He has paid that amount. Isn't it? Page 155. Now kindly see what he actually is required to pay as per 74(5).
First of all,
50%.
see what is the relief rate is against the search and seizure. We are talking about this case by law, this comes later. So we see the prayer midnight. So on the last occasion, what we were not inclined even to continue the interim mode, so we can modify.
I modified it.
Yes.
So that you can take the action.
Yes, that's why my lord, we see.
Now, what is the relief sought for here?
28. This part will come later. We have stated in our affidavit, my lord. We have yet to proceed as per the provisions of 74 or 73. Page 28. Basically, my lord, the warrant.
And where is the professional tax being searched upon you? Yes, Mr. Das.
Yes, I'm sorry.
You are asking for 21,78,000
Yes.
professional tax. How
Yes.
do we know?
Yes. Yes. Put aside. Page 74, kindly see, ma'am.
74.
74.
Yes, what is this?
It starts from, actually, it starts from before the 51, it starts.
No,
Fine.
I understood, but why do you say that professional tax have been charged?
They have charged.
Where,
GST authority has charged.
where is it?
Yes. Page 51 is a chart. Chalan, my lord.
So
51.
these are challans upon you making the payment.
Yes.
You have paid along with interest.
Yes. They asked me to pay, that's why I paid.
Mr. Das, my question is very simple. Why are you saying that they are charging you to a professional tax? Professional tax?
My lord, during this search, when they have searched, we started from 31/7/2025 till 5/8/2025. They recovered 6.5 crores, that's one, by GS authority. And they also demanded, my lord, professional tax to be paid. So that's the reason why 21 lakhs was paid. Please see, my lord, please see 12, my lord. 12 of my read petition first.
One.
151.
Yes.
Not registered under the.
Huh?
They are not registered. Page 152, we have given the after describing the provisions of the act.
But do you have a power to charge professional tax by going into his house without a demand? Where's your demand?
He has voluntarily paid, madam.
What voluntary? Oh,
No, voluntarily, how can there be a payment of professional tax?
they have done lot of things during certain season. I know what
think,
they have done.
you
They have
should
detained.
restricting yourself to whatever it is. You are carrying out a search under section 67. The search is done under 67 too. So once you are carrying on the search that these are there, and then what is there and search and then cease. After that, you go for investigation under 70. So therefore, where is the one? Why you are mixing up everything?
Paragraph, page 12.
And you have paid that 21 lakhs.
I what to do? They came, no, don't say this is, they came to my premises not from 31/7 to 5/8, detain all the person. They said that this pay amount 6.5, we paid on protest. Secondly, they said you have to pay the professional tax, which I mentioned in my writ petition. See page 12. PCP is page 12. This is my averment which has been made. Please see. KL, my lord. Yes, please see, my lord. At page 12.
Annexus 6. Where is Annexus 6?
Page 51 onwards. 50 onwards. Page 50 onwards, my lord.
Annexus. No, this 21 lakhs.
Yes. 50 onwards, my lord. 50, 51 up to 75, my lord. Summary. Please see 75, my lord. The summary of 75. Total 21.
Let's see the Professional Tax Act.
Yes.
It is somewhere here.
Ah.
Where is your notice of demand? professional tax?
No notice.
Huh? How is it possible?
No, it is possible. Why? Because if you see at 88, this officer came to my premises, and all these are my officer who has sworn an affidavit, and this affidavit has been annexed before this court. How coercion, in what manner, my lord, please see at page 89. How they recovered the amount. Please see at page 89. Please see 89.
How did they know that they had to pay 6,50,000, 6 crores 50? Because it is, the amount is exactly what you have assessed. How is it possible? No, I think we need to catch hold of these officers. I'm told that they are creating havoc.
Well,
These GST officers.
my lord,
And otherwise you put them to arrest.
my lord, they lost.
That you can. No, the Supreme Court passed an order na? To the effect that I think till you don't serve a particular copy out there, then till then, I think anticipatory bail is also not permissible.
Yeah.
69 minutes.
Please,
Under section 69,
my lord, please see 80. Ex-ample officer, please see 87. Please see 87. And there's a search warrant. See who has done it. Driver. The driver has signed. Witness. See page 87. Please see 87. The Panchnama. See on down below. Oh, driver is illegal. No, driver. Oh. Sign in SMEs, my lord. These are not also independent witnesses. They're officials. This is how they have done it, my lord.
But without a notice of demand, how can you compel somebody to make payment?
Our statement is that they make voluntary payment. Voluntarily they make that.
Without a notice of demand.
They have paid man.
Seven-
Under coercion, they have paid man.
76 is DRC is a file under protest. This is file under protest. Affidavit, he said voluntary I paid. It is in protest.
Under protest, they may
Yes,
it is a voluntary payment because they know that they will go for litigation.
And from 5/8 till today, you have not taken any action under 74(6).
That I will pay. We will take up next week, my lord. I will pay the entire record of the proceeding.
Call the, my lord, one humble request. I never request, but call the officer, my lord. He will lose the case, no problem. My lord, call the officer. See the state of affair of the officer. From 31/7 till 5/8, we could not bring nothing, my lord. They detain us. This is the state of the officer, my lord. Great respect, I am saying. Don't mind, my lord, we lose the case also. But these officers should come to the court and give a, your lordship, definitely ask them why they have done it. My lord, you issue notice, definitely I tell my client also notice, reply, everything.
Reminds me of that movie, na? What is the name? Raid.
Raid.
No, it was not as such.
No, it is as such. No, it is as such. Why it is as such? Because I have made the averment also. I made averment also. and already affidavit had been shown by the officers itself, employee itself.
But I think the CBC must be issuing instructions in this regard, how it is to be
This
done.
is 381, that's what I have shown. 381 instruction, please see instruction at page 381.
When a board has left the necessary.
381. 382 is 11, my lord. Para 3 and 4, my lord. Para 3 and 4.
So when they are making the payment at the protest,
This is what Radhika Agarwal judgment says, my lord. 2025 6 SCC, my lord.
when they are making the
545.
payment at the protest itself says that it is not voluntary.
Yes.
Protest, my lord, in
Yeah.
the sense they have made the payment.
You course me, you are saying now.
And this
Yes.
instruction, my lord, we have.
Please see, my lord. 67, my lord. Para 67. Instruction has been quoted from page 66, my lord. Para 66. Para 66. And para 67, my lord. And then para 70, my lord. 67, then para 70.
So therefore we ask them to refund the amount
Yes.
and ask the commissioner to take disciplinary action
Against that officer, man.
No, your reply doesn't seem to be good because the moment you have acknowledged by DRC 04 means you have seen that down below, written it, that it is payment made under protest on account of the search.
Online payment, automatically it will be generated.
But why did you acknowledge?
The payment made, my lord, it have to be acknowledged. It is gone to the
No, under protest.
Para 24 or 150. How they came to know about.
And the fact that you have not issued a notice subsequent thereto further shows that you are satisfied.
No, my lord.
1 year has gone. You have not taken any notice.
No, on the last occasion, what he had modified it. Not that, my lord, before that, my lord, there was an order that no coercive action.
No coercive action is a different
There's
thing.
things that is pending.
Yeah, by that time, you
I
see,
participated.
have you seen section 75(1)?
Well, after coercive measure also, I participated. Let them say that I didn't participate. I participated. Why is saying that that no coercive, nothing has been? I
So
participated.
without there being a stay, nothing is there. Coercive
Yes.
measure is not stay.
No, I participated after summons.
They should, my lord, not proceed, my lord.
There's
No.
if you have done it, then you do it at your own risk. But that is not there. But the fact that you have received the amount, acknowledged it, and have not informed him thereafter, because he's otherwise going to have to pay further payment, interest. For the last 1 year, you have not said that he is entitled, he's liable to pay further amount. It admits that you have received it and you are satisfied with that. Because you see, the main problem is the assessment, whatever may be, the assessment can only be removed, can be made, or set it not only by only one way, by way of a proceedings under 73, 75. So if you are not doing it, then the assessment has attained finality. Then he's entitled to the refund. Matter over. Not satisfied. Not satisfied. No, records would not make any sense taking into account because you have not taken the subsequent action.
No, whatever action has been taken during the pendency of the decision, then I will place it on it.
So you need to very well say that, okay, we are not satisfied with this amount. This is the amount. First of all, you say that there is no.
The satisfaction part won't come because the inspection is not over, madam. He has not cooperated, madam. Documents were yet to be submitted. That's why I'm saying I will place it on record, madam.
What?
We can ascertain it, madam, that this is the
15,000
specific
pages.
amount by some demand and all. Only when, madam, we come to a conclusion, madam. That has not been, madam, yet completed, madam.
So as of now, you don't know what is the amount payable.
That's why I'm
After
saying I
more
will have
than a
the
year.
specific instruction on records, I can place it, madam. What has transpired subsequently.
Because you yourself say in your affidavit
Madam.
that this is the amount payable by the by the petitioner,
Well,
6.5 crores
madam,
in the table, and he has paid that exactly the same amount, even to that particular rupee. See, there you categorically mention as per us this amount, and as per this petitioner has paid this. Only as regards the earlier amount, 39 lakhs, and he has paid 23. Then or should we take the affidavit to be the notice to him? What?
No, in, I'll just tell one thing. My lord, your lordship has modified the order at paragraph 5, and I'll bring on record that we participate in pursuance to the court's order. 7,000 document, and my learned friend is saying for the court, we didn't participate. If he is trying to place record, we'll also place record before the court.
Yeah.
Let the officer be called, my lord, as the best part. I think is the best. Let the officer give an answer to the court and why he have done it.
No, only thing is this, Mr. Gugoi, you have to understand this. Because who is going to pay the interest? Because if you, the moment you issue the notice, if you are not satisfied, then he has to pay an additional amount. Then also he is given another chance. Now he pays with 25% penalty. You have to inform him that this amount which you have paid. Your stand is we did not say anything. He on his own make the payment. But his categorical stand is this. So you do one thing, you refund the amount to him, initiate proceedings on the basis of that. Matter over. Simple.
One day, madam, I will come up with.
No. We cannot, yeah, no time.
So one day, madam. Some instructions I can say on place.
Hey, Hunaksun, next time P. Gogoi comes up with an urgent matter, no urgency. Ballot. All your matters will not be done till this matter is finished.
Deliberation.
But we want next Thursday, madam.
No, absolutely no. Why should I have it on next Thursday? You have not done anything, why should I have it next Thursday? But I think we need to do one thing, you return, I think you should refund it. Because the concept of voluntary payment is without protest.
We will take a call on the next day, can we finally.
The-
It is a convenient.
Many other cases are there.
I understand. That's for that. Let it be on the day, madam. Next week or any day convenient.
I have not been able to finish off many of my judgments which have been delivered also, correcting also I have not been able to finish up. Taking into account this month of August, there is not a single holiday.
Now, my lord, September Lord will be, my lord, for-
Much better. than- Otherwise, it's a big problem making the, because I dictated it to 4 stenographers. After dictating, they give me the judgments. One has to look into it. I'm slow enough, not being able to do that. And because of you, today I'm going slow because of the thing. Otherwise, what is this Biani's judgment?
No, no, I have not given.
This is it. This is the Biani judgment. You have looked into?
Yes, yes, that we are. Regarding 53, my lord, 69, 3 no.
69. About reasons to believe. Hearing remains incomplete. List this matter again on when? এইখন কেনে হলো? Twenty-seven, 16 matter. Eighth of September.
8.
Well, the NF Railway Authorities has issued the tender for turnkey contract for the work of supply installation, commissioning of plant equipment and related infrastructure, and operation of mechanized laundry at Badarpur, which include collection of soiled linen from coaches from Agartala, Silchar, Sairang railway station, loading of washed linen into coaches at Agartala, Silchar, Sairang railway station for a period of 10 years under boot, build, own, operate and transfer basis, and transportation of linen from boot laundry to nominated stations, including on-board distribution of linen to passenger, blanket repair and stitching of curtains. But this is the scope of the work, my lord, that lordship find at page 37, my lord. The value of the work was, my lord, 1 crore 182 crores 27 lakhs odd, my lord. Now, my lord, the petitioner and the private respondent participated in the tender process, my lords. And the petitioner was disqualified on technical ground. And, my lord, the reasons which they assigned, my lord, in their letter communicated to us, my lord, wherein, my lord, it was indicated that there are basically 2 grounds for which the petitioner's bid was rejected. One was, my lord, that the banking certificate, my lord, that the petitioner was required to submit, it did not board the signature of the chartered accountant, my lord. That was in the realm of the financial criteria, my lord. They say that this is a mandatory conditions, my lord, and I have not complied with that. Second ground, my lord, they say that the petitioner has not having the technically qualification. And for that, they only refer to only one format, my lord, where the experience was required. And they want to read it that the said document should also include in it requirement as regards setting up the laundry, my lord, which my response submission, my lord, this is not the requirement. Requirement is there, but it is in a different form in different annexures, my lords. These are the 2 basically grounds that have been taken by the railway, my lord.
You read from paragraph 6 to 9. 6 to 9 of you, my order passed.
Yes, my lord. My lord had taken note of, my lord.
This is your, sir, this is your case.
Yes. My lord will have a order, my lord.
Paragraph 6.
Yes. May I read, my lord?
The two reasons are
My lord.
at paragraph 3.
Yes, my lord. Paragraph 3 is
Technically non-responsible primarily for two reasons.
Right.
First, the banking reference certificate which is required to be submitted by the petitioner through those submitted was not certified by the chartered accountant with stamp, signature and membership number.
my lord.
Second is the petitioner did not have the technical experience of the competence of setting up a mechanized laundry of minimum capacity of 4 tons of linen per shift while washing minimum of 4 tons of linen per shift for a continuous period of 12 months in the qualifying year, that is the current year and previous 3 financial years.
My lord.
Now your submission is at paragraph number 6.
My lord.
You said that clause 1.3 of part 1 of the notice inviting tender, which is with the heading system of tendering, stipulates the financial criteria. Referring to so and so of the demand, the learned counsel for the petitioner submitted that there is a requirement of submission of the audited balance sheet duly certified by the chartered accountant, oblique certificate from the chartered accountant duly supported by the audited balance sheet.
My lord.
The learned counsel submitted that there is no dispute that the petitioner had duly submitted the audited balance sheet duly certified by the chartered accountant. Referring to clause B of subclause B of the Iman, the learned counsel submitted that the liquidity aspect has been duly mentioned, which should have be the value at 5% of the estimated bid value of the applicant's commitment for other contracts. In that regard, the learned counsel submitted that to prove the liquidity, there is a requirement of submission of documents as per format prescribed in 20 and 21. The learned counsel further submitted that taking into account that the petitioner did not have 5% of the estimated bid value at the liquidity in its balance sheet during the financial year 2025-26, as the petitioner's liquidity was only 7 crores so and so, which otherwise should have been 9.11 crores. The petitioner submitted a banking reference in the form of the bank certificate in the format provided in so and so, wherein the senior manager of ER certified that the said bank was willing to provide overdraft of the credit facility to the extent of 9.2 crores to meet the petitioner's working capital requirement for executing the said work. Learned counsel submitted that the perusal of the format of PIA would make it clear that the said document need not be certified by the chartered accountant, inasmuch as the certificate has to be only issued by the senior bank manager, along with the address, which was duly done so as would be apparent from page number 214 of the writ petition. The learned counsel, referring to the grounds, stipulated that the banking reference document should be certified by the chartered accountant on the basis of the second paragraph of so and so of remand submitted, that the same has been completely misplaced, as it is the audited balance sheet which has to be certified by the chartered accountant. And in the circumstance, the audited balance sheet contains liquid assets, lines of credit and other financial means which would meet 5% of the estimated value. There is no requirement for issuance of a certificate in terms with Annexure 20. The learned counsel therefore submitted that it is under such circumstances the words have been used as and or between the two documents, namely audited balance sheet and banking reference. This is as regards the banking reference.
Yes, but in addition to that, my lord, the clarification by the Southern Railway, my lord, I have relied upon page 251.
Southern
Yes.
Railways on that.
Yes.
The learned counsel for the petitioner as second ground for rejection submitted that the said ground is completely misconceived, inasmuch as the petitioner duly submitted the required documents in terms with annexure so and so, which are different and separate aspects dealing with the technical experience, that is setting up of mechanized laundry of a minimum capacity of 4 tons of linen per shift while washing minimum of 4 tons of linen per shift for a continuous period of 12 months in the qualifying period, that is the current year and the 3 previous. For the petitioner submitted that issuance insistence upon the respondent that Annexure 12 should contain the setting up of the mechanism is completely misconceived. Inasmuch as it is in 12 capital A, the said aspect is conceptualized. This is your case.
Yes. But your lordship has to read with another annexures, my lords, whether the requirement of the technical qualification is provided, my lord. Because there are details of the laundry has to be given in a separate form. That is not contained in 12. What 12?
And that was very much there.
Yes, yes.
In Annexure 12A.
12A, 12B, and my lord, there are also annexure 15. There also the details is required to be given that we have given. What requirement is, my lord, that under 12, it should be the quantum of the work that has to be completed should be related to one unit, my lord. And that certificate should also contain, and rather it contains the details or the address of the laundry from which this work has been executed. But now they want to read that you have to set up this laundry within this qualification period, my lord. That is not the terms of the conditions of the tender, my lord.
Now, what do you want they say?
They say that, Lord, I have to execute the work. I should have a setup of my laundry. And they give me a period, 3 years and the current year, under which I have to complete the turnover part. Now, what they intend to insist upon is that the setup should be within these 3 years. But both requirements they are reading into this document, Lord.
Of the current financial year and the previous 3 years.
Previous 3 years, Lord.
Setup of the laundry.
Yes, yes. But that is not the language of the Lord, tender documents, Lord.
Let's see the tender
My lord.
document.
My lord, kindly come to page 51, my lord.
Yes.
1.1, my lord. Technical criteria. As proof of technical experience competence, the tenderers must satisfy the following criteria. Should have setting up a mechanized laundry of minimum capacity of 4 tons of linen per shift while washing minimum of 4 tons of linen per shift for a continuous period of 12 months in the qualifying period, that is the current year and 3 previous financial years, my lords. In the case above, laundry services should have rendered to one of the more following establishments, clients. But these are the clients which have work done for private individuals shall not be considered. Now coming to the note, my lord. For the purpose of technical criteria above, a mechanized laundry unit shall mean a laundry facility installed in a single premise. Now, for substantiating the requirement of having washed at least an average quantity of 4 tons of linen per shift in one site for a continuous period of 12 months in the qualifying period, that is current year and 3 previous financial years, the tenderer should be required to furnish documentary evidence as per Annexure 12, certified by one or more institutional clients mentioned in para 1.1 above. It shall be noted that only information submitted in Annexure Roman 13 should be considered, but it should be actually Roman 12, not 13, because that is not applicable for in this case. Documents in any other form like letter of acceptance, completion certificate, etc. shall not be considered. For the laundry of minimum capacity of 4 tons of linen per shift in one site, which the average quantity of 4 tons per shift has been washed for at least 1 year, the tenderer should submit information as per Annexure 12A. So, 12A is also required to be furnished. Technical and financial eligibility of the JV form shall be adjusted based on the satisfactory fulfillment of the following criteria. This is not required in my case because I am not JV, Lord. The operation of laundry of minimum capacity of 4 tons of linen per shift shall be either directly through Indian partner, or this is all requirement as regard the tenderer shall submit satisfactory performance certificate from some of the major institutional clients. Railway reserve the right to seek independent confirmation of credentials submitted by the tenderer. But I have instructions, my lord, that they have also sought verification from the department from which we were working, my lord. Now, my lord, your lordship would see the capacity in the note. Capacity of 4 ton mean the capacity of 4 ton linen per shift. This shall be reckoned as the output of the main washing equipment of the laundry, washer cum extractor or tunnel washer in a shift of 8 hours, that is 24. Tenderer has to submit the
So
documents.
this means in 24 hours is how much?
Shift,
One shift is 8 hours.
8 hours, 3 shift,
So 24 hours is?
3 shift, my lord.
So it will be around 12.
My lord.
Means it's a continuous period of 8 hours.
8 hours.
So there in 8 hours, you should have the capacity to have 4 tons.
Yes. My lord, also the 1.1.2, my lord. For the purpose of technical criteria above, a mechanized laundry shall mean a laundry facility installed in a single premise. So one cannot have, my lord, the work to be done from 2 separate laundry. It has to be
One
from
side.
one side. For substantiating the requirement of having washed 4 tons of linen per shift for a continuous period of 1 year in clause 1.1 above, the tenderer will be required to furnish a documentary evidence as per Annexure 12 certified by the concerned establishment clients.
So this is in terms with this one.
Yes.
1.1 Roman 2. Isn't it?
Yes, my lord. The tenderers are also required to furnish the detailed particulars and as per Annexure 12A towards identification of the single mechanized laundry and details of annual payments received on account of laundry operation as per Annexure 12B. So in addition to that, my lord, the payment should also be linked to the laundry service, my lord.
The 12A says for the laundry of minimum capacity of 4 tons of linen per shift in one side, which the average of 4 tons per shift has been washed for at least 1 year, the tenderer should submit information in so and so. Now, what are they saying?
My lord, initially, my lord, what we had instructions was that our tender was rejected, my lord, only on the conditions that we had not signed that certificate. Later on, my lord, when when the matter was moved, my lord, they submitted one letter, my lord, which they have never served us, my lord, which indicated this. And this letter was also not very clear in what. Only when they file this affidavit, my lord, they say relying on Annexure 12, they say I don't fulfill. They never my lord, indicated it that I am completing this requirement in terms of other annexures also, my lord.
Now, you just said something, they had a problem with it, means. Now, let us see your annexure.
My lord.
Annexure 12.
My lord. Lord, if your lordship permit, Lord, I can show it the entire set of annexures I have submitted in the affidavit in reply, my lord.
File an affidavit in reply.
Yes, yes.
Page 326.
Page 3.
Huh? Page.
Page 326, if your lordship's take up.
This is in terms with Annexure 12.
Yes, my lord.
Annexure 12 requires what?
Lord, if your lordship would see Annexure 12 in the tender, let your lordship find at page 144 of the tender documents, my lords.
So experience certificate, name of the work, so and so, agreement, so and so, contract value, and so.
Lord, value of payment is also there. And registered office and name and address. My lord will also see column 4, address of the laundry premises. So this has to be identified. My lord, kindly note the address. plot number 252, block C9, New Auto, Karma, Vijayawada. But private respondent has made us in their response, they have said that this unit is functioning from the hospital, which is not correct, Lord, because it has got separate address and it's been separately installed. And this detail lordship find in other annexure also, my lord, whether I have given the details of my laundries.
Okay, let us hear madam about this. Explain to me what do you mean by this?
As it is said that they were not aware of the reason of rejection of their lots of technical brief. They have admitted in their lots of website.
Let us not go into those technical, no, let us not go into those technical things. I'm not considering what Mr. R. Dubey is saying on the aspect pertaining to that this was not informed and all. I'm not on that. My question is there are two folds. First thing I'm a bit satisfied with is on the second aspect, which is the most pertinent aspect, is whether he has the technical qualification. Now, what is your stand? Let us understand from your affidavit why he does not meet that.
Our level at page 72 of our affidavit.
Your affidavit is at page 252. Saibasasi Day. Saibasasi Day. Huh? Who has filed it? 272. 272 is not there. 252. Anyways, let us understand from respondent numbers 1 to 5. Then the evaluation gives decline according to the conditions there.
Submit the document to prove that he has completed similar nature of works. And second is regarding he failed to submit documents regarding P2 eligibility. That's what liquid asset.
So you mean to say in Annexure 12 certificate, there has to be also mentioning of mechanized laundry, setting up.
Should have the experience of setting up of mechanized laundry lodging. At page 28 short notice, short content on this lodging, the definition of similar work.
Page 28. 28.
20. This is the definition of similar work.
Where?
Regarding special technical criteria, 2.
Huh?
2 lots. Page 28.
Where?
Special technical criteria.
Put the mic down a bit. Yes to you. Yes.
Under the special technical criteria,
Page.
page 28. Page 2.
Where do I find? Ah, yes. As proof of technical layer, they must satisfy the following criteria. Should have setting up a mechanized laundry of minimum capacity of 4 tons of linen per shift while washing. Yeah. Okay. Now, Mr. Dubey, this is a area for supply of linen and mechanized laundry service.
My lord.
Now, for setting up from this place, do you have an annexure?
Yes, yes.
Certificate?
Page 382, your lordship would see. From my reply, my lord.
The 15.
Yes.
No. This certificate is required to be given by whom?
Lord, this annexure 12 certificate has to be given by the Lord,
Institution.
institution for whom I am working. And
Does it mention that in that certificate there is a requirement of placing that aspect?
no. It says that the name of the laundry should be address should be mentioned, which I showed to your lordship, my lord.
For substantiating of a demand of average annual of 4 tons in one shift for a continuous period of 12 months in a qualifying, should have setting up a mechanized laundry of minimum capacity of 4 tons of linen per shift. Okay, so this is the criteria.
Yes. And
Now, this criteria is to be certified by whom?
by the, my lord, the authority, like Director of Medical Education has certified in this my certificate.
No, that you have set up.
My lord,
Certificate at 326
yes.
is for supply of linen and mechanized laundry service.
But it contains a column wherein the address of my laundry is also to be mentioned as well as its capacity, per day washing capacity. Lordship,
Let us see the 12.
Lordship would see
Annexure 12, wait.
column 4 of this certificate if your lordship sees.
12. So and so, name and address of our issuing certificate, so and so, address of the laundry operator in whom this certificate is issued. And so, details of the linen wash. The details of the linen wash should be done for a continuous period of so and so. The above quantities are so and so. So there in the form at Annexure 12, which is at page 144. You mean to say that the work concerned should be for setting up of should have setting up a mechanized laundry of minimum capacity. So this certificate should mention that, but there is no column for that. of the laundry operator to whom this certificate is issued, address so and so, so and so, so and so. So chapter 12, annexure 12
And
does not.
Annexure 12, A law,
Huh?
Annexure 12A,
12A.
12A.
Multiple tender identity of single layer so and so in which they have washed so and so. Now who has this is to be signed by him.
Yes.
Lordship, yeah.
It is to be signed by him, and he has submitted that.
No, Lordship, he has submitted the experience certificate 193.
One
193, page 193. This is issued by the Director of Medical Education.
Same page 326, my lord.
page not 193. It is 267.
And here, Lordship, the subject, Lordship. 193.
He has submitted 193.
Under subject column, he said here planning, linen and laundry services, supply of linen and mechanized laundry service by MS so and so. So as part of
So it does not mention setting up.
setting up of mechanized laundry logic. It says about planning.
But
washing
but where is it mentioned that the annexure 12 certificate should contain that? Let us see page 51. For substantiating the requirement of having washed at least an average quantity of 4 tons of linen per shift in one site for a continuous period of 12 months in the qualifying period, that is the current year and the 3-year, tenderer shall furnish, is required to furnish documentary evidence as the 12 certified by one or more instrument mentioned in para 1.1 above. Okay, then for laundry of minimum capacity of 4 tons per shift in one site, which the average quantity of air has been washed for at least in 1 year, the tenderer should submit information as so and so. Now kindly come to 1.12. For substantiating the requirement of having washed 4 tons of linen per shift for a continuous period of 1 year in so and so, the tenderer shall required to furnish under so and so. Where is it mentioned in 12A or in 1.12 or even in 1.1 Roman 2 that there is a requirement for this?
Not in 52, page 52 note, Lordship.
Where?
Capacity of 4 tons shall mean the capacity of 4 ton linen per shift.
Yes, per shift.
This shall be reckoned as the output of the main washing equipment in the laundry, washer cum extractor or connect washer in a shift of 8 hours, that is 24 hours. Tenderer has to submit the documents to prove that he has operated installed minimum of 4 ton capacity laundry per shift. So he has to submit the documents, Lordship, that he has.
Where?
The last line, Lordship. Tenderers has to submit the document
To prove that he has operated installed minimum 4 tons capacity laundry per shift.
per shift.
So this is a different document.
He has to submit a
This is not in terms with 12. This is not in terms with chapter 12. Now, what is the document to be submitted? Now, the private respondent must have submitted some document to that effect. What is the document the private respondent submitted in that regard?
Lordship, any documents in our only the actual certificate issued by the medical affairs, Lordship. At page 267 of our affidavit. This is the experience certificate he has submitted.
This is he has submitted. No, I'm not on him. Private respondent. Because what other certificate he has submitted? If you mean to say, tenderer has to submit the documents to prove that he has operated, installed minimum 4-ton capacity laundry per shift. Now, if he has to submit, there again, it is not mentioned out here in this note, it has to be mechanized. It doesn't say it to be mechanized. The ground which has been mentioned in your affidavit is that the petitioner did not submit the certificate that it for setting up of mechanized laundry. That is your case. That he had the qualification for that he had set up the mechanized laundry. So therefore, you see, you mean to say that in terms with the technical criterion mentioned in 1.1, which says page 51, should have set up a mechanized laundry of minimum capacity of 4 tons of linen per shift, while washing minimum of 4 tons of linen per shift for a continuous period of 12 months in the qualifying period, that is current year and 3 financial years. So he has to set up a minimum capacity. Now, who is to give the certificate?
Experience certificate is to be given by the.
Where is it mentioned? Where is it mentioned? Because Annexure 12 does not say so.
Because
Kindly see, Annexure 12 is only to substantiate 4 tons of linen per shift.
Lordship, the agency, it is mentioned in the same, the agency who will give the Lordship experience certificate. This is 1.1 Lordship. In the case about laundry, services should have been rendered to one or more of the following establishments clients.
Understood.
Yes.
This is okay.
Here
My question is here. Annexure 12 is to be certified by the person concerned, by the institution, as per 1.1. Annexure 12 does not say, at 1.1, Roman 2 does not say that for substantiating the requirement of having washed so and so, this is the certificate to be given. Because otherwise 193 says, linen and laundry service, supply of linen and mechanized laundry service by so and so. So therefore it indicates that there is a laundry service, there is a mechanized laundry service in set up at the address of the laundry service at so and so. It is there. Now what is required is 4 tons. He has per shift.
Lordship, whether he has the experience of setting up the mechanized laundry, this is required, Lordship.
Who will give that certificate? Because he has otherwise given 12A.
Given by the agency, Lordship, who employed him for this contract work, Lordship. Here, the experience certificate only said about the washing and distribution of wash linen, Lordship. It nowhere said about the setting up of a laundry.
What?
This experience certificate nowhere stated that issued by the Director of Medical Education. Here it only said about the washing of the linen and distribution of the same.
It also says up there, na? Supply of linen. Now the subject is not there. Not required. But what is required is here. Name of the work, supply of linen and mechanized laundry service. So are you therefore saying that the word setting is not there? In this service, in this detailed name of the work, it is not there. For that you have done it. That's your case.
Not only that, Lordship, regarding bank reference, so bank reference.
Bank reference, we are coming later on. First, this is it.
Lordship, the name of the work itself said regarding the setting up of.
So the name of the work does not say so. Setting up.
Turnkey contract for the work of supply, installation.
Yes,
commissioning.
Mr. Dubey, you have you must be having the contract for this.
Yes, my lord will kindly have a look at page 366. My lord, the requirement has been, my lord, the annexure Roman 18 will clarify your lordships, my lords.
360.
My lord, kindly come to page 153, my lord.
153. What is
Yeah.
that?
And also,
Wait. Technical documents evidencing support of so and so.
So, my lord, it's not only from
Roman
annexure
1,
12.
Roman 2, Roman 3, AR, so and so, 15. Yes, now?
So for technically qualifying, Lord, I have to fulfill this, except 13 is not applicable in our case. And Lordship would also see in the bottom, Lord, Roman 2, numerical 2, financial criteria, 3 annexures.
Hmm.
So these are the requirements. Now, my lord, annexure Roman 12 says that I should have that much of certificate from them. Now, Roman 12 say that I have to made a list that is to be submitted by me. So it will contain the washeries and all. Then Roman 12a, my lord, the quantum I have received, and Roman 12b from what, and Roman 15, my lord, is the list of the laundries. I'll show you lordships, that what we have submitted.
Is that 15? Where do we get Roman 15 here?
Roman 12a, my lord, will get at page at page 366.
This is you have to give.
Yes, 12a, my lord. I have many, my lord, washeries, my lord, laundries.
Then you have given this.
Yes.
Then
And Roman 15, your lordship would kindly have a look.
Roman
15. Before that, I'll show your lordships Roman 12b also. Page 370, if your lordship sees.
No, where is Roman 15?
Roman 15, 378, my lord.
385.
378, my lord, is start. Oh, sorry, 380.
This is a certificate by you.
Yes. It
Let
starts.
us see how
Start at 381, my lord.
how the tender mentions about Roman 15. Where is it?
Roman 12a has been mentioned in 51a.
No, why there is Roman 15? Somewhere it is
Yes,
not
yes.
mentioned. Why? 12b, 12, 19, 20, liquidity, so and so. Yeah, 4, 5. Previous work done, legal shall submit. Where is Roman 15?
Roman 15.
Yes, where is Roman 15? Yes, Mr. Rahul. You make your submissions.
One more aspect, my lord. My lord, their financial bid had been open, my lord. And we have also made a statement to the effect that they have made a bid of 216 crores, my lords, and our bid is 200 crores, subject to if your lordship permit.
Two grounds that were shown in the my lord, for rejection of this thing. One, my lord, that endorsement by the CA, my lord. That kind of we are not arguing much, my lord, I reject your lordship. But insofar as the my lord, technical qualification is concerned, my lord, that technical.
Because I think that does not hold, because you see, tell me, the most pertinent thing, the reason why they have done it is absolutely inconceivable that a particular a certificate issued in original by the ICICI bank is to be attested by the CA. It's very difficult to approve. And if they are asking it, how can he attest? Unless, because just for example, a lawyer, a certificate given by the lawyer, by the bank, can the lawyer attest it? No. That is the thing which, yes, a document which is of balance sheet, all these things, if the CA has done, he will attest it.
Which is written by the CA.
Yeah, because he has to attest his document. It cannot be that, because that is a wrong understanding. But anyway, but I think the main point hinges on the technical qualification.
Like regarding kind of similar.
Similar work, yeah. Now, where is the certificate required?
Not I'm coming to that. But the kind of entire deliberations have been confined to matter that annexer 12. My argument would be slightly different. I'll develop my argument in a particular manner. But first of all, I would like to again draw your lordship's kind attention to that affidavit of the railways. In paragraph 9, they have cited the ground. Page 257.
257.
257.
Yes.
Of the paragraph 9, the NIT further stipulated that documentary evidence substantiating the aforesaid eligibility are required to be furnished in the prescribed formats.
Wait, 200 and?
Lordship,
200 and?
257.
Annexure 12. Yeah, okay.
No,
Just one.
the affidavit filed by the
Paragraph 8.
paragraph 9, my lord.
This is the documentary evidence.
NIT further stipulates that documentary evidence substantiating the aforesaid eligibility were required to be furnished in the prescribed formats. There are many formats, by the way. And only documents conforming to the tender conditions would be considered. The tender document further prescribed in separate criteria titled definition of similar work. I am laying emphasis on this one. Definition of similar work requiring proof that the bidder undertaken so and so and the similar work. Now, my lord, if your lordship peruses their rejection, their letter, my lord, that issued by the respondent, 272. 272, my lord, annexure C of their affidavit, my lord.
Not satisfied the prescribed technical and have failed to submit the in your bid that you have completed with conform to the definition of similar.
Documents in your bid to prove that you have completed works which conform the definition of similar nature of work as per the tender.
Mr. Rahul, I understand one thing.
Lordship.
What you are trying to say, or she is trying to say is similar work means as have been mentioned in clause 1.1.
Yes.
Page 51.
Yes.
That is washing 4 tons per shift in a single site, including setting up of a mechanized laundry.
Setting up.
I understand that your submission or her submission is setting up of mechanized laundry. And the submission is based upon the fact that the certificate which is there of the petitioner does not say that setting up of the mechanized
Not
laundry.
only to that, not only to that, madam. There is another annexure, madam, which is required to be filled.
Which one?
Yes, madam. If
That
you
is the-
it comes to page 56, my lord, of the writ petition.
Page 56.
Just one moment, my lord. Page 28 for a moment, my lord, just 20. It has already been read, my lord, I am just referring. It is a mandatory field. That is what I am want to. Page 28, the special technical criteria table, my lord. If your lordship peruses the special, the serial number 1. As proof of technical experience, competent tenderers must satisfy the following criteria. Should have setting up mechanized laundry of minimum capacity of 4 tons of linen per shift, while washing minimum 4 tons of linen per shift for a continuous period of 12 months in the qualifying period. I pause here, my lord. Now, should have setting up, my lord. This is a mandatory field and it has been indicated to be mandatory. Document uploading mandatory, my lord.
To one or more of the following year. Confirmation required. What is this confirmation? Remarks allowed, documents uploading allowed means?
My lord, this is the, my lord, tender condition, my lord. This is the format where the, my lord, it is mandatory, they have to upload these documents, my lord.
So confirmation is not required.
Confirmation required, no.
Remarks
allowed,
required, no.
But document,
Uploaded here, confirmation entered by the bidders against any evidence shall be opened and part of the technique. Okay, then
now, my lord, document, what documents will be uploaded? Those will be the annexures. Now, I am taking your lordship to page number 56.
yes.
Clause number 1.4.1.1. Technical bid. The technical bid shall consist of number 1, EMD. Number 2, proof of meeting technical eligible criteria as per clause 1.1 above. Has your lordship got it, my lord? And at the same time, I will come to another clause, my lord, clause 6. List of similar works, my lord. List of similar works completed on ongoing in the qualifying period, that is current year of 3 previous financial years, should be provided as per Annexure 2 and Annexure 3. This is very important. This is what I am harping upon.
Annexure 2 and Annexure 3.
Annexure 3, my lord.
So it is not Annexure 12.
Not 12, my lord. Now, Annexure 2, the format, first I will take your lordship to the format, then their whatever they have submitted. The format is available in page number 124. This answers to your lordship's query regarding agreement or no.
List of similar work completed in the
List
qualifying.
completed in the qualifying period, clause 1.1.
So these similar works will also be setting up of a mechanized.
2, my lord.
Yes.
Now, if we come to their documents, it is available from 305, page 305 of their rejoinder. Then executed in reply, your lordship comes to page 305. my lord.
Yes.
This is, and if your lordship just observes near the date indicated 3326, it's mentioned Annexure 2. This is
Page
the Annexure 2
305.
uploading.
Huh?
This is the Annexure 2 uploading done by them.
On which date?
305. There's a date mentioned, my lord.
305.
Yes, ma'am. And there's a mentioning of the annexure, ma'am. That is what I am trying to draw home. Annexure 2. Just nearby the date mentioned, my lord.
Okay. Annexure 2, huh?
So list of works completed, my lord, now.
Yes. Difficult to
Number
read.
is
it.
collection of soil linen from nominated coaches. This is
Huh?
not setting up. Number 2 is supplying of wash linen. This is not setting up. 3 is supply of wash linen, 4 and so on, my lord. If your lordship goes to each and every entries,
Nothing is setting up.
nothing is setting up.
So it is not under 12, it is under 2.
It is under 2, my lord. Because the NIT has to be read and understood as a whole, my lord. And if I have understood the, my lord, lordship is, my lord, well versed, my lord, Baxi Securities, if any relaxation is given, then it has to be clearly spelled out.
So 12 will be a certificate.
Will be certificate.
And 12, we may also have a relevance out here. Let us again come to 28. This is 12. 12 will be uh, So here, if we again come to page 56, supporting document certificates from the organization from which the standards have been worked should be enclosed. The authorized signatory should sign the certificate submitted by the tender from the private individual. Whatsoever here shall not be. So therefore, there has to be a certificate to the effect that there has been a setting up of a mechanized. That's it.
I'm not putting my. No, if they say there is a confusion is sought to be, my liner thread submitted, my lord, as per his understanding, that setting up requirement is not there in the tender. What is required, if I can show that I have a capacity of particular loan?
No. That I don't agree.
Yes.
Because 1.1 is absolutely clear. Should have setting up a mechanized laundry of ear.
If at all any confusion remains, because this NIT encloses the contract also. Nowadays, it provides the contract. The special conditions of contract, my lord, at page 66.
Page?
Page 66, my lord.
Come to it,
Page 66, the repetition, my lord.
Yes.
Page 66, concession to be provided by the railway, 3.4 lordship, as your lordship got.
Yes.
Land. My lord, setting up is a sine qua non in this contract, my lord. The successful bidder will be provided railway land on license up to a maximum limit of 2,000 square meters for setting up laundry at Badarpur.
So therefore, the experience is required. Okay, done.
Another slide.
One more.
Last one. Just
So
one.
why?
My lord,
Remaining argue before when he files an appeal before the division bench. Unsatisfied. That is the only thing which I was just because he's referring to annexure 12, 12A and all. But the more pertinent document are those documents. 2. And the certificates to be given in as regards setting up.
even my lord, the machineries which they have indicated, the documents which they have provided are my machinery. That is what I wanted to show your lordship.
What?
My lord, some machinery documents, my lord. This is another provision in the, my lord, same page 56, my lord. In furtherance of that particular clause, they have submitted certain supportive documents in the tender. Those are my machineries, my lord. My firm's name is indicated.
Your sister concerns?
Okay.
Your sister concerns?
No. My lord, I'm saying, we are JV, my lord.
You are the JV.
I'm a JV, and my lead partner's name is there, my lord, in those documents, my lord.
Huh?
Those documents which they want to project that are their machineries, the name is inserted in my firm. So
You are a JV.
I'm a JV.
Okay. Wherein their lead partner
Our lead partner
is
Tharu and Sons, and his certificates have been shown to be there.
Anyways, that's beside the point. Yes, Mr.
Well, coming to the last issue which my friend has raised.
Nothing to
No,
do.
my lord, it says, my lord, this is a wrong interpretation of the annexures. My lord, the document says that what this kind of machinery is where it has been used.
Mr. Dubey, I'm not going to go into those.
My lord.
One point is enough for deciding contract matters.
my lord,
I have all along under a misapprehension. First point, you had a good point.
my lord, second,
Second point,
my lord, I'd like to respond to it, my lord.
respond.
My lord, it is not that I have not set up, my lord, because annexure 5, my lord will
Where
kindly have,
is your certificate to the effect that you have set up?
my lord,
Because as per annexure, as per this particular clause at 1.1.2, 1.1.21, Roman 6, you are required to provide certificates by the institutions that you have set up.
my lord, come to first, I'll answer to it, my lord. Lordship would kindly come to page 56, my lord.
Why?
My lord, that Roman 15, my lord,
What is
requirement.
this now? Roman 15. Yes, what is it?
Top, my lord, Roman 1. Past performance of tenderers in other boot tenders of Indian Railways like time taken commission boot loan will be considered for technical evaluation of the tender. Lord, it is not a case I have not set up. 12A is the list of the laundries which I have set up, my lord, and 15 is further, my lord, which they required.
What?
And my lord, the requirement is that it should not. My lord, if your lordship see the certificate itself.
Do one thing, we vacate the interim order now, order shall follow.
My lord will kindly have a look at the my lord, certificate.
Enough. You have got a stay for that. Remaining is enough. Remain, I'll pass it out.
My lord will kindly have a look, my lord.
Interim order vacated.
Regarding bank certificate losses, as far as checklist losses, it is mandatory.
No. That it's okay. One point is okay.
My lord will kindly have a. My lord, the annexure 18 I have shown to your lordships, my lords. It says for technical qualification requirement is Roman 15 action has to be read with 12A, 12B, 12C.
All are understood, but annexure 2 is there.
Lord, annexure 2 does not say as regard the setting up. Your lordship sees that annexure 2.
Yes, it says so.
It doesn't say so, my lord.
It says so.
No,
As regards similar
with due
experience.
respect, my lord.
It says so similar.
My lord will see what it's, and I have furnished that. Whatever the requirement is, I have furnished in my annexure 2.
No, it is not there.
My lord will kindly see.
Show me a document where you have submitted that it is, you have set up a mechanized AR, there is a certificate. Show me one.
My lord, that I have to provide, my lord, that they have to inspect.
No.
My lord, so far as because the laundry which have been mentioned in my certificate is correlated to annexure 15.
No,
That certificate
you kindly see. 1 point here. Supporting document certificates from the organization for which the tender has work should be enclosed.
My lord, that is the second in format annexure Roman 12, my lord.
Mr.
My lord will kindly have a look at Roman.
I allow this thing. We allow it. This is a case for dismissal. Dismissed. Hello. Heard. Dismissed. Pass the order. Heard Mr. R. Dubey, the learned counsel appearing on behalf of the petitioner. Miss RDB appearing on behalf of the Railway Administration. 125. And Mr. G. Rahul appears on behalf of the respondent number 6. This court have heard the learned counsels appearing on behalf of the parties at length. This court have also taken note of the urgency shown by the learned counsel appearing on behalf of the respondent. Stating inter alia that in view of the interim order passed by this court, the railways are in difficulty in providing the, what do you mention? Laundry. No, you don't do laundry. What do you give? You give something, na? They wash. You wash, what do you give? To the passengers, what do you give?
They wash and also distribute lordship.
Huh?
So distribute
It's a
is
composite contract, my lord.
Huh?
Composite contract of washing and supply.
washing and supply.
What do,
process lordship.
what is?
Linen, my lord.
Name of the work phase 26, madam. Name of the work.
Facing great difficulty. In view of the stay order, facing great difficulty in
Supply, installation, commissioning.
providing the linen in the distribution of linen to passengers, linen blankets to the passengers. So,
To collect the soil linen lordship and they have to wash it and
etc. We have put in a word, etc.
that's it.
Taking into account, having heard the petition, the parties, this court is not satisfied. It is of the, it is the opinion of this court that the petitioner have failed to make out a case for interference to the decision of the respondent authorities in rejecting the petitioner's technical bid. Accordingly, the writ petition, accordingly, the interim order passed on 15/7/2026 stands vacated. The writ petition also stands dismissed. Detailed order is passed in separate sheet. I stands disposed into order duty.
Thank you.
Take that.
Today we have filed the application, we have served a copy of the application.
You filed?
Yes.
Affidavit having been filed by the PHE, held PHE. The learned counsel or appearing on behalf of the PHE submits that the affidavit in opposition has been filed. Reply?
Not required.
What is the matter about?
Now, the technical sanction was wrong, for which that was never corrected
The
and
counsel appearing on behalf of the petitioner submits that the petitioner would not like to file any reply. Registry shall list this matter again on 16th of September 2026, along with the said affidavit in opposition.
God bless you.
What is this?
Lordship is regarding non-release of my security deposits, your lordship. Lordship may peruse your lordship's order dated 10/6.
Another affidavit filed.
Another has been filed, your lordship.
Yes.
Lordship, they have come with another mechanism, your lordship.
No, not another mechanism.
Lordship.
That is the mechanism, because of that, the difficulty we are facing. Lordship may kindly take up my affidavit. In fact, that mechanism, the EMARC portal, the difficulty, they are not only facing in this project, they are facing this particular problem in the 298 project.
In respect of this project, including other projects also, they are facing that problem. So therefore, they have taken up the matter with the central authority, and accordingly, a solution they have arrived at.
Madam, you go through this. Take it
Lo-
on
y-
summons.
Yes, your lordship. Lordship, I've gone
And
through
if
it,
you
your
want to
lordship.
file a reply,
Lordship, if your lordship peruses annexure 3, your lordship, page
this
98.
new affidavit.
New affidavit, your lordship, page 98, your lordship.
Urgent completion of so and so closer year for Iman.
Also, they have identified 298 road packages, which are still lying as extended packages in the DLP module of EMARC, and their DLP completion formalities have not yet been finalized, your lordship.
So they've been informed that the review meeting is final.
So they will be conducting a joint survey, joint inspection, and there will be some compliance report from the contractor, your lordship. Point number 4, your lordship, upload all requisite documents in the EMARC portal and complete the DLP completion process at the earliest, your lordship. So my DLP, lordship, that the issue has been already completed in the year 2024 when the certificates were issued to that effect, your lordship.
No, it is not complete
And,
in the EMARC portal. And in respect
Lordship.
in respect of the petitioner, in paragraph 10, we have indicated, paragraph 10, page 88.
Lordship,
Let her complete.
Lordship. Lordship may also come to paragraph 2, your lordship, of the present paragraph 2.
Yes.
Lordship, paragraph 3, sorry, your lordship. Paragraph 3, that the deponent respectfully states that original 5-year defect liability period in respect of package so-and-so expired on 23/11/2024. Thereafter, certain observations were raised by the state quality monitor, and those were duly verified and formally cleared by the state quality coordinator on 23/3/2025, your lordship, which is annexure 1, your lord. Annexure 1. Lordship, it is at page 90, your lordship. And relevant portion is at page 94, your lordship. This is the remark, your lordship, of the inspection report. Since the ATR submitted by PIU has been found adequate along with photographs, hence it is accepted at this end, your lordship.
State quality control.
Lordship. This inspection was done, and after that, your lordship, here it has been admitted in the affidavit. After that, the certificates were issued, your lordship. So now they come up with a new mechanism, your lordship, that there will be some inspection. Now, if they do some inspection, your lordship, there will be field examination, your lordship, and the roads will never be in a very good condition because those
And
lordship.
they have now intentionally done it during monsoons.
Lordship. So they will never be in a good condition, your lordship. So they have come with another
What has
mechanism.
happened? You are PWD. What has happened to the new road which has been constructed from Gauhati, Chalmari to High Court? Now because of the flyover, people move out there. Ground floor means the earlier road is after the rains have finished. Is not in good order.
And your lordship, in your lordship's order, your lordship 10/6/2026, your lordship had already given your lordship's opinion that they have unduly not made payments, your lordship. That I have been deprived of my dues, your lordship, unreasonably.
Interest has to be imposed.
Lordship, because on the interest they were supposed to give their opinion, your lordship.
So in this affidavit, in this affidavit, we have indicated what difficulty we have faced.
No, your difficulty is,
So kindly
first of all, I will consider once your officer is suspended.
Kindly come to para 10 of this.
First, your officer has to be suspended. Show me the suspension order, then I will consider.
No, my brother friend has
Including.
shown 2-3 paragraphs. Kindly come to para 10.
No, no.
No, in the present.
Is it mentioned that the officer has been suspended?
Para 10, can you-
Otherwise, no. Sorry.
In the new solution, in the new the mechanism, the inspection has been done, and they have said that within 2 weeks it is already cleared. Within 2 weeks it will be released. Para 10, 96 page 88.
No way. This type of action is not here.
Kindly see para 10. Page 88.
You don't feel like giving, you are not giving.
No, it is because of the e-mark portal and that.
Your,
they have
what?
already taken up the
No,
measures.
is it in the tender conditions that after the demarc portal is given, then it will happen? Now, show me the tender condition which says that it is only then the completion certificate would be admitted.
Because of the central government instruction we have placed, kindly see at now at this stage para 10 kindly see. It is the process is already complete. Within 2 weeks the amount will be released.
Anyways,
It is-
I'll have it on some other day, but I think it's high time
Not sure.
to pass an order. Today I have to pass another order, so it's. Huh?
It is the affidavit we have said.
Not
that
satisfied.
Within 2 weeks it will be released. They have said that the inspection has been done. Kindly see para 10 for me.
What is that?
Para 10.
What does it say?
Para 10. Page 80.
Yes.
Due to the automated DLT extension process in the e-mark system in force, the security deposit could not be released to the petitioner, and that non-release of the security deposit amount is not intentional. The important article states that the steps have been taken to release the security deposit amount after the specific instruction in the review meeting of NRIDA and NIC recall, and the instruction dated 15/7/2026 as stated. The security and the performance deposit of the petitioner will be released after completion of the
Procedure, your lordship.
within 2 weeks.
And
It has-
We'll have it after 2 weeks.
But-
You release it then.
Yes, it may have after 2.
Better off, because you see, whatever may be, he has to get the amount. You see, the first, some officials have to be, I think the best way is let us keep the interest aspect there so that we can penalize these type of officers as a deterrent.
What we have said.
No, as a deterrent, it is necessary, because otherwise, because of that, PWD is facing a trouble. We are concerned about the government of Assam, not the officials. I think it's high time. And these executive officers, yes. I don't trust these executive officers of PWD. PWD executive officers is very difficult. And because of these PWD executive officers, the Supreme Court have totally struck down the site inspection site visit certificate. Now you don't have, I suppose. You can't have it in view of the judgment of the Supreme Court. And it has become, because of that, it's all, the problem has been created by the executive engineers. And because of that, the benefit had been taken by Mr. S. Hawk. Anyways, we have it here. Taking into account the statements made in the additional affidavit, more particularly at paragraph number 10 of the paragraph number 10, comma, this court fixes this matter again on 29th of September 2026 for an update. Yes, I'll rise.
May I please, Your Lordship? I have a very urgent matter, Your Lordship. Item number 20. My appeal has been pending with the Secretary, Judicial Department since 8 months, Lordship. And
What
the
happened?
matter has not reached since 1 month.
Happened? They have sought for comments from the Registrar General. What has happened? Huh? item number?
Item number 20, Lordship. Let it be at 2 p.m., Lordship, then it will come.
When the matter was last listed before this court, the Judicial Department of the Government of Assam apprised this court that on account of non-receipt of the comments from the Gauhati High Court, the appeal could not be taken up for disposal. Full stop. List this matter again on 2nd of September 2026, on which date Mr. N.K. Sharma, the Standing Counsel of the Gauhati High Court, shall apprise this court as to whether the Registrar General of the Gauhati High Court have forwarded the comments to the Judicial Department of the Government of Assam.
At 2 p.m., Lordship, I'll be highly obliged.
No, not necessary. You mentioned the matter on that day, morning.
Deeply obliged.
Liberty given to the petitioner to mention the matter for upgrading.
Deeply
Your matter, Mr. Pathak, I've taken care of your request in the morning with a punishment to the effect that you remain here till 5.
Not at all. Otherwise, what had fallen from your lordship on the last case, that some modality has to be.
Now, if the modality is not there, it will have a cascading effect. It is become, because that day I closed down some of the contempt matters yesterday. The PWD were asking for money. Now, in this case, what has happened, he has used this particular mix, which he has purchased from somebody. And that somebody has made the mix on the basis of certain stones taken from somebody. And that person has purchased the stones from somebody, and that person who has purchased the stones has got the stones from the person who had what you call mined.
Yes.
So he's the sixth person. How can you recover from him? It is already payable from there.
What the recovery has been sought to be done is from the agency who is procuring their service. So that's where another.
No, the problem what arises is last time what has happened is in those matters is they will deposit in the treasury. It will go to your head of account. And because of such numerous things, you are not in a position to assert it. In those cases which are yesterday closed, these are contempt petitions of 2018. There the PWD said that we have already taken the money, we deposited. Now the forest is, for the last 8 years, is not able to ascertain where their money has gone. This is the fact. So we need to do it urgently for something. That is your case?
Yes, my lord.
When I think the best option is to say that you have no business to do it, because as per law you can't do it.
Yes.
Rule 5 has to be read with Rule 8 and 9, and more particularly 8 and 28, 27. 8 and 27 has to be, because it is either the mining contract holder or whatever may be, they are the persons who are to make the payment. From them you can't, because only thing is how do you channelize it?
Yes.
Because they cannot get it.
Yes.
I understand they may be resourceful from getting it from somewhere, but it is not the position how they. Therefore, I dealt with the GMC thing, where the GMC were asking from everybody some money. I said, no, you can't do that. For getting a, GMC was putting that you have to pay 2% or 5% royalty on the total construction cost for the purpose of this. So I've set aside this, you can't do that. So the same principle
Same,
will
my lord,
apply.
2%. Same 2%.
So it's the same thing which has to be done. But only thing is that sometimes it becomes very difficult. You need to track it out, how it is to be done. That is the only way I'm asking. But I don't now trust the officials because they have not been able to do anything. If the advocates help us, it's okay. Okay. This matter again for further hearing on 10th of September.
Obliged, my lord.